May please.
From item numbers 1 to 4. Number 5 to 13.
Might be the lunch. I'm praying for listing of a retail bill day after tomorrow.
Correct. Right now we are taking adjournment prayers.
Please, your lordships. With the consent of the other side, I beg to mention item number 12 and 13 of the daily list, your lordships. In this matter,
Item number 13,
12 and 13, your lordships.
12 and 13, yes.
In this matter, Senior Counsel Mr. D. Das appears, your lordships. He is out of station. Lordships may
It is
adjourn
stated
matters.
that Senior Counsel Mr. D. Das is not available. Who would be leading the matters is not available today, and a prayer is made to adjourn the matter. List up to 2 weeks
Deeply obliged.
as per it. Okay.
Numbers 14 to 20.
May I plead the lordship? Lordship, item number, I recommend item number 18, lordship.
Yes, what happened, madam?
For respondent number 6, lordship.
Yes,
I need further time to file affidavit in opposition, lordship.
what do you say? When Counsel MS so and so appearing for the respondent number 6, prays for and is granted 3 weeks time to file affidavit in opposition. List up to 3 weeks.
Date may be fixed.
Fix the date up to 3 weeks, whatever it is.
Oblige.
Obliged.
Lordship, I'd like to mention item number 20.
20.
20.
Why?
But, I'm supposed to file the affidavit in opposition. Well, some clarifications are yet to be received.
Okay, I am for the appellate lordship. My only anxiety is that lordship, the matter is getting delayed lordship. On the last occasions also lordship.
Yes, we have seen the file.
I understand
We
the
already granted you few opportunities.
Lordship.
I understand the hurdle of the
Correct.
respondent lordship.
All right, Mr. Not
Only for
appearing
1
for
week,
the
lordship.
state authorities, come on.
Lordship.
Wait for is granted and is granted last opportunity to file affidavit in opposition.
Yes, yes.
Affidavit in opposition. List on
Lordship, any date lordship.
7 June.
7.
My lord, lordship.
Can it be, my lord, after 7 June, because we are also going to file affidavit, my lord. We need some more time.
You will be filing affidavit on behalf of
Time, my lord.
Lordship.
7 June will be after 2 weeks.
8 June, lordship.
8 June.
8 June.
All right.
Much obliged.
Okay.
Number 23 to 35.
Your lordship, I'm praying for an adjournment in item numbers 27 and 28, your lordship.
Why?
Mr. Learned Senior Advocate, Mr. D. Das appears in this matter as he's out of station, your lordship.
You didn't even indicate, sir.
Yes.
It's really not fair. They stated that Senior Advocate Mr. D. Das would be leading the matters and he is not available today. Thus, a request is made to adjourn the cases for the day. Place the matters after 2 weeks. List accordingly.
I'm grateful, your lord.
Yes.
Lordship, I have mentioned for listing of retail bill tomorrow. My lord, reason behind is that, my lord, the Guwahati Municipal Corporation issued a notice, demolition notice, but without complying the basic procedure of law, my lord. And
When was your writ petition decided, sir?
my lord, that writ petition was decided to give 7 days time. 7 days time is over today, my lord.
When, what is the date of the impugned order, sir?
Impugned order, my lord, that was 3/5/2023.
So you are now coming after 15
No,
days.
my lord, no, that order was passed on 15, my lord. 15/5/2023, passed by the learned single.
Tomorrow.
But
Make the lordship. My lord, I am praying for a listing of a retail bill day after tomorrow, my lord.
What is the matter about?
My lord, the matter is about seniority dispute between 2 assistant teachers.
What is the date of the impugned order, sir?
My lord, date of the impugned order is 5th of January 2023, but it was uploaded on 19th of May. 19th of May, last Friday. No? Day after
Yeah,
tomorrow.
day after tomorrow.
Deeply.
Yes.
Lordship, in item number 11, I have filed an impediment application. Lordship, I may be allowed to
On behalf of,
on behalf of the Andhra Pradesh.
let the matter come up. Let the matter come up. Orders matters, let them be called out.
I beg to
Yes.
mention rateable that may be taken in 25th May.
Is it a fresh matter, sir? Then,
Rateable of 29 to 2019.
so what happened suddenly? Why you want to get it listed?
Today no, not is not.
Can't hear you, sir. What do you want?
I want to list if you want to.
Rupam, check what is the problem.
25.
Take this slip.
Wait, please, Lordship. Lordship, like to mention a matter for urgent listing day after tomorrow, Lordship.
What is the matter?
Writ appeal, Lordship, the single judge order was passed on 4th of May. But we have instituted our writ appeal on 9th of May, but still it's not listed on the regular course.
All right. Listing on the regular list 20, day after tomorrow.
Obliged.
Okay.
My lord, against the judgment of Central Administrative Tribunal Guwahati, a writ petition under Article 226 read with 227 has been filed before this honorable court. The judgment was passed on 12 May 2020.
When do you want to get it listed, sir?
Yes, I want to get it listed if possible on urgent basis today. Or
Today, not possible, sir. Day after tomorrow.
My lord, may it be listed tomorrow because
Wait, what is the urgency?
the urgency is transfer. The petitioner has been
Transfer matters, there is no urgency. There is
My lord.
never any urgency.
My lord, the petitioner is on this preparatory leave for 10 days. The judgment was passed on 12 May 2020, 12 May 2023. And he's on preparatory leave for 10 days only, which expires tomorrow, my lord. Therefore, kindly grant us the matter to be heard tomorrow.
List tomorrow. All right.
Much obliged, my lord.
Yes.
May I pray before item regarding item number 14. Item number 14,
14, yes.
it may be adjourned for 2 weeks.
And counsel, you are for the appellant.
Yeah, yes, yes.
And counsel for the appellant, place for time. And list up for 3 weeks.
May I place your lordship?
Must obey.
I beg to mention for listing, that this is a contempt matter. The order dated 26/4/2023.
All right. It is listed on 22nd.
27.
All right.
Obliged.
Yes.
Second,
22nd.
22nd what? Today is 10.
So today is 22nd. Oh, sorry. I was looking at the calendar. 25th. 20. Yes.
Item number 1 for orders.
Wait, please, Lordship.
Yes.
This is an appeal preferred by the state, Miller. While preparing the appeal, there is a delay of 39 days, and we have taken steps on
What
5.
happened in the connected writ appeal 211?
This is also pending, my lord.
Are you sure?
Yes, my lord.
What is the report on service? Today it is for await service report.
Yes, my lord.
So that order was passed on 3rd February. Why it was not listed? 3 weeks time. Tell them they are not supposed to keep the files back. All right. The office has reported, the Lavazima court has reported that service is deemed to be completed on response numbers 1, 2, and 3. No one has appeared on their behalf. This is the matter. This is an matter comes up for orders on the interlocutory application filed by the state seeking condonation of delay of 39 days occasion in filing of the connected writ appeal. It is stated that against the very same judgment which is challenged in this appeal, the state has filed another appeal, which is writ appeal number 211/2017 and is pending consideration of this court. In this way, the matter, we find the reasons set out in the interlocutory application seeking condonation of delay to be germane. Hence, the same is accepted. Delay is condoned. Registration number the connected writ appeal and list the same for admission after 1 week, along with writ appeal number so and so.
Obliged, Lordship.
Item number 2.
May it please, your Lordship.
Yes.
Similar applications of delay condonation. So in this matter, there is a delay of 332 days. Now, the only.
What is the date of writ appeal number 12/18? There is one more writ appeal in this matter.
Yes, your Lordship.
12/18.
Yes, your Lordship.
What happened in that?
17. The date is 16/7/2018. The order was passed when it was admitted, and there was a stay order also granted, your Lordship.
All right. What is the report on service?
It's deemed to be completed, Lordship.
Rupam, this was 2018. What are they doing? Find out what is this? What is this? But why so long? the Lavazima court has reported, this is an advocate application seeking condonation of delay of so and so days occasion in filing of the connected writ appeal. The Lavazima court has reported on 10/5/2023 that service may be deemed to have been completed on the respondents. No one has put in appearance on their behalf. Thus, the connected writ appeal number so and so
12.
filed against the very same impugn order has been admitted by this court.
Yes, sir.
Thus, finding the reasons mentioned in the application to be germane, we hereby accept the prayer for condonation delay. The application is allowed. The connected writ appeal shall be numbered and listed for admission.
Obliged, Your Honor.
Matter number 3.
There is no objection against condonation. You prayed for a time on the last date.
So we are filing an affidavit today, Your Lordship. During the due
Affidavit of objection.
objection. Lordship.
How many days is the delay?
300 days. Lordship.
We just now condone your 300 days.
Lordship will just allow me to file the objection and thereafter
Counsel.
condone. I have nothing to say thereafter. Just let me file it
We
today.
will be filing the objection affidavit today. List up 1 week.
Obliged. Your Lordship.
Matter number 4.
But we have got the status report. The husband of the petitioner is missing. Well, the status report has said that the investigation is going on. The photograph of the missing person has been circulated to all the SPs. Well,
Yes.
they also
Is it
taken up the
not?
matter with the Tamil Nadu police.
You fail to understand.
Logic.
Why have you not raised the objection of jurisdiction? What happened in Guwahati, which can give rise to this habeas corpus here? What happened in Assam for that matter? He is going to Tamil Nadu is voluntary.
True, Malad.
He went missing in Tamil Nadu. Why the Assam police is running after that?
But the FIR has been registered here.
Why it was registered?
Some.
You ask your officers.
Logic.
There is nothing incriminating, though there is no incriminating act.
No.
In Guwahati, even as per the admitted case of the petitioner.
Correct.
Correct, then what?
Logic. Malad, so far the steps are taken. We have placed the Malad. We'll file an affidavit. Malad.
There is nothing which has happened in Assam.
Nothing. Malad.
He went to Tamil Nadu on his own
Yes, Malad.
with certain persons. From there, he went missing.
Yes.
He called, someone is giving me this threat, that.
Correct. Correct.
Let the Tamil Nadu police do the things.
Logic. Logic.
It's not. He has been interrogated, but otherwise also. The man, even as per their own investigation, own allegation, the man calls from Tamil Nadu, says that I need assistance. The police is after. Yes, that is. So then he went missing thereafter. So there's no question of illegal detention in Assam. And then Counsel Mr. Nath, Committee Advocate Mr. Nath has filed the current status report on investigation of Kalgacha PS case number 183/2021, which indicates that the police authorities are still making efforts to trace out the missing person, Abdul Rauf. On a perusal of the records, what do you say, Mr. Counsel? How jurisdiction here?
Since the cause of action started from.
Let us see how. Let us see your own case.
Come to FIR.
Read, please, read.
Yes,
read.
my lord.
FIR at page number?
Page 18, my lord.
Yes.
The informant was respectfully based that on 6/2021 evening at about 4 p.m. the FIR above named accused person along with one person, unknown person came to my house and taken my husband.
All right. Now, during investigation,
Yes.
what your client has said, let us see that.
I have not.
Have you got the factual report?
The earlier report I have given.
Hmm.
It will.
My lord, I have received the report just now, my lord.
No, no, earlier report I have given.
Earlier report, sir,
Yes. yes.
even
In
we
in
did not
form
have
of
the,
affidavit we have filed.
even we did not have the today, the latest report. The earlier report is there with us.
Yes.
Let's read that.
In this regard, my lord, let the matter be listed after 1 or 2 weeks, my lord, I will participate.
Yes.
Yes.
Mr. Nath has raised an oral objection regarding maintainability of this habeas corpus petition, submitting that no part of the cause of action arose in the state of Assam so as to consider this habeas corpus petition in this court. List, counsel for the petitioner pays for time to respond to this submission. List on,
After 2 weeks, my lord.
not of 29th.
Obliged.
Mr. Nath shall keep the investigating officer present in the court with the case diary on that day.
Item number 5.
May it please the lordship.
Yes.
In this second lordship, we have to file an affidavit in reply lordship. And today I have filed lordship.
You filed it.
Yes, today I have filed lordship.
All right. This permanent, the for maintenance,
Maintenance little lordship.
8,000 rupees or 4,000 rupees.
Yes, lordship.
What's wrong in it?
Lord, this appeal is not maintainable before.
Why?
Because order has been passed under section 125 CRPC, my lord.
Yes.
And here he filed merit appeal under section 19 of.
Read Family Courts Act, sir. Order was passed by whom?
Family case.
Well, 19.2, my lord, is barred, my lord, 19.2,
Read please, Family Courts Act then.
lordship,
Yes. It has to be a criminal revision.
lordship.
What do you say, sir? Withdraw it and file a criminal revision, or we'll convert it?
Lordship may
19.2,
be
my lord.
converted lordship. I have
19.2.
made my prior lordship. So if it is not maintainable lordship, kindly may be converted lordship. It will be lordship.
Yes. No appeal shall lie from decree or order passed by so and so,
And that is after.
or from an order passed on so and so.
After
Yes.
September 9, my lord, of CRPC.
This may be converted kindly lordship.
Now,
But this, the entire thing has to be changed.
lordship.
The pleadings,
It will be same
And
lordship.
provision of law also we.
provision of law, DB, SB.
Lordship, here is also lordship, raise this question lordship, will very later lordship.
We'll direct the registry to convert it. He'll
Yes,
file the
we will.
amended cost act.
Yes, yes, lordship. It will be provided.
Mr.
I'm a soft lordship.
Ali has representing the respondent has raised a preliminary objection regarding maintainability of this appeal, contending that as the order under challenge was passed by the family court under section 125 CRPC within bracket chapter 9 of the CRPC, comma, appeal would not lie as per the mandate of section 19(2) of the Family Court Act. Faced with this situation, comma, learned counsel for the petitioner prays that the instant appeal may be ordered to be converted into a criminal revision.
Yes, lordship.
Ordered accordingly, the registry shall undertake proceedings for converting this appeal to be a criminal revision. Counsel for the petitioner shall file amended cost title within 7 days, whereafter, comma, the matter shall be listed before the concerned bench, having roster.
I have lordship.
Item number 6.
May I please, my lord, this registration of petition was dismissed.
Yes,
Non-position by order dated 30th March, my lord.
yes,
My lord, the petition are dismissed, my lord, on the ground that non-prosecution, my lord, that
50,000 was not paid.
compliance of the, my lord.
Yes,
It was, my lord, noted.
not continued. We have seen that. All right, talk about maintainability now.
My lord.
South Bank.
My lord, so far the section.
Yes,
Also for section 17, Surface Act is concerned, no doubt, my lord, the,
no doubt the Supreme Court has
they are,
passed strong remarks against the High Court's which entertain such writ petitions.
My lord,
Read, please. This is
but-
April 2023.
I agree, my lord, but my lord, in some cases, my lord, where the surface provision is not applicable in such. cases-
All right, you satisfy the DRT. Why the writ court is
My lord,
required?
first, my lord, my case is, my lord, this notice survey under section 13(2) is not maintainable under subsection 3 of section 13, my lord. Because, my lord, subsection 3, my lord, mandate that the details of, my lord, the amount outstanding due must be, my lord, disclosed in the notice, my lord.
What part of the challenge is cannot be examined by the DRT? Let us know
No,
from the act.
my lord, DRT, all these can be challenged.
Can be, then the
No,
jurisdiction
but-
is
but
exclusively with the
no,
DRT.
but my lord,
Show us one judgment to the contrary, please, Supreme Court.
no, Supreme Court says, my lord, that in not in all the cases, my lord, but in cases where the provisions.
Read these judgments, sir, 17th April 23. Read, please.
Writing of this judgment.
Read, please.
While doing so, we are conscious of the fact that the powers conferred under Article 226 of the Constitution are rather wide, but are required to be exercised only in extraordinary circumstances in matters pertaining to the proceedings and adjudicatory scheme. Qua a statute, not more so in commercial matters involving a lender and a borrower, where when the legislature.
Extraordinary circumstances. Now, what are the extraordinaries?
No, my lord, extraordinary only, my lord, no doubt, my lord, the questions raised by the, my lord, the petitioner can be answered by the.
Chapter closed,
Oh,
sir.
No, my lord. But my lord, my lord have to see, my lord, that in many of the cases, my lord, the banks are taking action under SRPC, my lord, where they should not have taken, my lord. So far, my case is concerned, my lord.
That is why the DRT is constituted, sir, to take care of such illegal action.
But my lord,
The remedy is provided in the statute.
But my lord, a judgment of DRT, my lord, it is specific to a specific case, my lord.
Yes.
But if a judgment is passed by this honorable court, my lord, that in such cases, the bank should not take an action.
You show us one Supreme Court judgment which says that in these circumstances, interference can be made.
No, but my lord, not in the honorable Supreme Court is only in extraordinary circumstances.
So tell us what are those extraordinary
My
circumstances?
lord, in my case, my lord,
Analogous to the facts involved in your case, give us one judgment. All right, give us one judgment of the High Court.
yes, my lord, there is a judgment of Gujarat High Court, my lord, in September,
Of which year?
22.
Let's see. Whether State Bank of Travancore was considered, State Bank of Travancore judgment was considered or not.
Not that, but my lord.
Not that, sir, then the judgment does not lay down the correct
But
law.
my lord, various other judgment of honorable Supreme Court has been considered in this judgment.
On what issue?
My lord, and then those Sabji Nayak and others versus Pradya Prakash Khadekar and others, and my lord, Missions Leather
Sir,
Limited.
what
versus
were
Canara
those
Bank.
judgments dealing with? Let us know.
My lord, these judgments are dealing with, my lord, only on the question that the banks, without application on mine, my lord, the bank should not take action in the surface, my lord. That was the precise question.
What is the concept of surface proceedings?
Well, the
A
concept is,
loanee fails to make payment of
no,
the loan, defaults in payment of loan. The bank is given a process of securing its dues. That's the only procedure prescribed.
My lord,
What more?
admittedly, my lord, that is the precise object of the act, my lord. But my lord, where the bank is at fault, my lord, when the bank is, my
For
lord,
that the mechanism is provided, Mr. God.
mechanism is provided, my lord, no doubt, but my lord, why the banks are, my lord, repeatedly committing such.
If you already file a PIL, we'll consider it in suitable case. Now we'll dismiss your petition on merits also. Okay, so we'll restore it and then dismiss it on merits. Okay, on maintainability. So that at least it doesn't come to his head.
No,
That's what the idea is.
But my lord, in my case, my lord, actually, my project was, my lord, a commercial real estate project, my lord. On the base, because of, my lord, this surface, my entire project.
You want to argue on merits? Then all right, we'll dismiss your restoration also. What is the ground to restore? Tell us. You are not there, we dismissed it. Simple. What's wrong in it? Neither you nor your client.
As you lordship think.
All right. Restoration allowed, writ petition dismissed on ground of maintainability. Yes, what do you want to say?
No, but I have no difficulty.
All right. Very well. Okay.
Matter number 7.
What is the matter about?
My lord, there's a delay with regard to 253 days, madam. In filing the writ appeal, my lord.
Any objection?
My lord, the ground zone is that suffered from the kidney problem and concerning advocates. Junior colleague also suffered an accident, madam.
Advocate's personal difficulty. The corrected writ appeal is delayed by
253 days, madam.
253 days. And local application number so and so has been moved, seeking condonation of delay primarily on the ground that the counsel representing the appellant was suffering from a kidney ailment and thus, timely steps could not be taken.
Applicant was suffering
from kidney ailment and thus, and that his advocate also suffered a road accident and that contributed to the delay. The respondents have not filed any objection against the prayer for condonation in view of the facts noted above, and finding that the delay has been satisfactorily explained, the same is condoned.
But orally it is objected, madam.
Oral objection, no written objection filed. Delay condoned, connected writ appeal shall be numbered and listed for admission.
Matter number 8.
May I please? Lordship,
yes.
There is a IA and in this regard, Lordship, we will file reply in this affidavit. Because some objection is there, and we have to file affidavit.
You are representing whom, sir?
I am for the petitioner.
Appellant. So IA is yours.
Lordship, they have filed an petition affidavit and
when?
Affidavit in opposition, and in this regard, Lordship, we will file.
When did you file it? It's not there on the record. Affidavit in opposition in the appeal.
Yes.
Or the IA.
In
It's only this month only.
In which proceeding have you filed the affidavit, sir?
It's in the matter bill also.
So like today it's for the IA praying for stay. Argue. Why should we stay? Your client has got 51 shops in Fancy Bazaar.
Yes, sir.
And he's not ready to pay his wife and children.
May I submit, Lordship? May I submit? Lordship, this I is filed for stay of the operation of the trial court below that impugned order, Lordship.
Yes.
And I don't have any objection in that.
You don't have any objection being stayed.
Yeah, it may be stayed because next, maybe Lordship, the next date may be fixed for the hearing, final hearing on that. But
Very well.
but
That's your
Lord-
choice.
But Lordship,
We'll
Uh,
record that then.
I have a prayer, Lordship. In the impugned order, Lordship, there is mention of certain exhibits. And those, that is at page 17, Lordship, in the matter appeal, Lordship.
Hmm.
Page 7, the mention of certain exhibits, and those were exhibited in the main divorce suit, Lordship.
Hmm.
So that divorce suit may be, entire record of that divorce suit may be called for, Lordship, the LCA record.
So your client has filed this application for permanent alimony just for mental satisfaction, it seems.
Not, Lord.
Then you say that you don't have any problem in the decree being stayed.
Lordship, the respondent has the right, Lordship, to appeal. So during the pendency of the appeal only.
All right. The matter comes up for orders on the interlocutory application number so and so, seeking stay on the impugned judgment and decree dated so and so, whereby, permanent alimony to the tune of ₹1 crore was ordered to be paid to the respondent, being the erstwhile wife of the appellant, here. Counsel for the respondent submits that he has no objection to the decree being stayed. In view of the peculiar facts noted above, we hereby direct that the respondent shall remain present in the court on the next day.
Well, the LCA record may be called for only. In
The lower court record shall be called.
FC civil case number 589/2014.
Why you get certified copies and file them? Why should we call the record? Procure certified copies and file them. You keep your client present in the court on the next date.
No, the exhibits are there, Lordship.
So you get the certified copies. What is the problem?
Lord.
Those proceedings will be stalled unnecessarily. List on.
Lordship, that this proceeding will not be stayed. The divorce is already granted, Lordship. So in that
So
case.
that's a concluded proceeding.
Yes.
A record of so and so shall also be summoned.
FC civil
List
case-
on 29th. On that day, keep your client here. And you also, the party shall remain present in the court. Yes.
Number 9.
The respondent number 2 has filed an affidavit today morning, madam. I've been served a copy, madam.
Hmm.
So I'd like to file a reply and go through and file a reply and stay for some time, madam.
What is the matter about?
So it's about certain districts of Kachar, villages of Kachar district, have been transferred for administrative purpose to with the Hailakandi district, causing
There
inconvenience.
are few more matters of the similar nature. Mr.
Those are a
AG.
little bit different. They are the whole challenge regarding the amalgamation of the district is challenge. Here, certain villages were transferred from district to the other
Okay.
district.
Affidavit has been filed
Today morning.
affidavit on behalf of the state has been filed today by Learned Advocate General Mr. Saikia. Mr. Datta, representing the petitioner, prays for short opportunity to file a response to the said affidavit list after 2 weeks.
Keep the language.
Matter number 10.
This is an application for condemnation of delay of 13 days.
Hmm.
Notice.
Notice has to be issued.
My lord.
Issue notice of the interlocutory application to the respondents. Respondents steps for service be taken in 3 days, whereupon process be issued. Thus
Dusty may be allowed.
the service is permitted. Rule is made returnable in 3 weeks.
My lord. Oblige.
Matter number 11.
Yes.
Lordship, I'm appearing for the petitioner in this matter.
Hmm.
The respondents were directed by the order dated 8/5/2023 to file a preliminary response on the
Yes,
on this
madam.
particular petition, my lord, but
Hmm.
the response has not been filed as yet.
Hold on. Yes,
Lordship, I have
This
received,
matter is relating to the imported.
hold on,
fish.
we understand. Hold on.
Lordship, I
We
have
are-
received the instruction in the evening of Friday, Lordship. So
Hmm.
I just seek a week's time, Lordship, so that we can file the affidavit.
Madam Bhattacharjee, praise for it is granted. Further opportunity of 7 days to file the requisite response in terms of the order dated 8/5/2023.
Lordship, in this matter, we have filed an improvement application today.
It's not come up, let it come up on the next day. All right. Senior Counsel, Mr. So-and-so puts an appearance on behalf of the pro forma respondent number 4. List on 30th May.
My lord, deeply obliged, my lord.
Yes. Madam, as a matter of fact, this should be, Madam Bhattacharjee, this should be a matter of concern for all of you also.
Yes, Lordship. Yes, Lord.
You should
Yes, I
treat
think-
yourself to be in the shoes of the petitioner. Nobody is benefited by eating this kind of
Yes,
stuff.
Lordship. The government already has taken appropriate steps, Lordship, but the report they are relying, Lordship, they have found some discrepancies, Lordship. So we will bring all this in record, Lordship.
All right. Very well.
The number 15.
Yes. They are appearing from VC or what? No. Yes.
My lord, here, my lord, the PIL was regarding, my lord, the central government and state government providing.
Funds
of
in
funds.
KAC.
Yes.
Yes.
This is for non-completion of road projects.
All right.
Under
Since
various-
when the projects were started?
Since the year 2017-18.
17-18.
Now, if your lordship will kindly come to page 23,
Yes.
this is the list of schemes which you have annexure A,
Just-
page 23.
Okay.
Now, as per this scheme, my lord, several road projects have been taken up under various, my lord, state government scheme and under central government scheme.
Hmm.
Very categorically. it
Is the
stated.
central government represented?
Central government, my lord, the fund has been given to the, directly to the.
Directly to the KAC.
Yeah. Now, what happened, my lord? Most of the projects we have found, my lord, from their affidavit.
Fund is not directly given to IAC directly.
We will, yes.
If your lordship will kindly take up their affidavit dated 5/1/22, additional affidavit of respondent number 8 and 9,
Page number?
file on 5/1/2022. The additional affidavit of respondent 8, my lord. They have referred to this list, my lord,
Affidavit in opposition is by the state.
by the respondent.
State would be a formal party.
Chief engineer, my lord. PWD, chief engineer.
Basically, we are concerned with the affidavit on behalf of the council.
Yes, yes. Now, why I'm referring to this, my lord?
Is there any page? Is there a pagination? That's what we want to know. Affidavit by
By respondent 8, my lord, and 9. It was in that affidavit, details of the work has been.
just respond number 8. Yes, we have.
Yes. Page
Yes.
number 4, my lord. Annexure 1A. That contains the details of the work. In this annexure 1A, my lord, most of the scheme during the pendency of this PIL has been shown to be, my lord, completed, my lord. Although at serial number 3A, my lord, some of the road projects are shown to be construction road from Virola, Taralangso is 70%.
All right. Annexure
some-
B, details of work. Yes. Yes.
Below, if your lordship will come, my lord, paragraph 3A. Construction-
55%.
Yes, some 70%, 55%. So my humble prayer will be at least, although there are other issues, my lord. If a positive direction is issued to them to complete all the works, my lord.
Yes.
Then to that.
Council.
My lord, that direction can be issued, my lord. All the roads has been completed, my lord. We have filed an additional affidavit also.
When?
Yes. We have filed 2 affidavits, my lord. One is filing on 1/3/2021, annexing all the photographs of.
That is the affidavit he was reading.
My lord.
That is the affidavit he was reading.
My lord, my lord.
Thereafter what?
Thereafter, we have filed a pilot.
When?
On 4/1/2022, that we have annexed, my lord, only one road that is working in progress, my lord. That is case 7 of that our.
Has there been any audit of these works?
My lord, that.
Because they have made an allegation.
My lord.
So should we direct someone to make an independent assessment of the works you have carried out? Why shouldn't that be done? Ultimately, you are getting funds which are being spent, as we are seeing in that criminal matter, which are being spent right, left and center without any check and balance. Why shouldn't we direct audit by an independent agency?
My lord, they are, my lord, complained that we have not completed the route, my lord.
There is another complaint of misutilization of funds.
Yes,
So why not an independent audit into that?
Audit generally. Done by,
Audit
my lord.
means that would be a proper inquiry.
My lord.
Maybe by a senior police officer. Why not?
My lord, before, at that stage, my lord, if they have filed any complaint before the police that we have misused.
They have made allegations in this PIL.
They have not, they have only made a statement.
All right, let us know. Let us know. Who is the senior most officer in your council? On your administration?
Principal secretary is the senior most IS.
So you file an affidavit of the principal secretary that there is a mechanism for monitoring all these works. You file the affidavit. We want to be satisfied.
By the principal secretary.
Yes. Then council, Mr. So and so appearing for the response numbers 6, 7, 8, 9, 10.
Pilot 6, 7 to 11, 13 and 14.
Submits that the roads in question, construction of the roads in question,
Except
which
one.
are except one, which are the subject matter of this public interest litigation, has almost been completed. However, from a perusal of the averments made in the PIL, we find that the petitioner has also alleged that there has been a misutilization of funds. First off, since the works in question are being undertaken in a 6th schedule area, there should be in existence a extra mechanism, an additional mechanism for checks and balances for the utilization of funds accorded by the central government and the state government for development of these areas. We therefore direct that affidavit of the principal secretary of the AAC shall be filed on record by the next date so as to satisfy the court that there is a proper mechanism to monitor the works in question so as to ensure that the funds so allotted are being utilized properly. The affidavit will be filed by next date, list on 5th June.
Item number 16.
Yes.
Please, your lordship may kindly pass over this matter for the time being. The Advocate General of Nagaland will be arguing this case.
Is he here?
Yes, he is in Guwahati.
All right. Pass. We have passed over the matter and Advocate General is yet to come. Yes. We have passed over the matter, madam. We'll take it up in the second round. All right. Okay. Yes. Next.
Item number 17.
May I appeal, your lordship? Lordship, in this case, I am applying for response number 3, my lord. Lordship, we have to file a response. So, lordship, I am.
You have to file?
Reply, my lord.
This is a writ appeal.
Read, lordship.
Pleadings are there in writ petition.
Yes, otherwise.
Then.
Record of writ petition is available here, my lord.
So it has been filed.
Lordship.
So why additional pleadings are required?
Yes,
let us know.
Because some statement against me has been made in this writ appeal, my lord.
At what point? Which para? Point out. Not for the sake of it, sir. What is that additional fact pleaded in the appeal which requires a fresh reply? No.
Lordship, paragraph 13, my lord.
Read, please. Yes. Was it not a ground in the appeal, writ petition?
Lordship, their allegation is that I had been conferred
You represent which respondent?
writ petition, my lord.
Okay. You have got the degree from an off-campus university.
No, my lord, that is not the issue, my lord.
Then?
The issue is that while appointing me, my lord, in 1983, my lord, there was a condition that I have to obtain the master MPhil or PhD within 7 years. And that was as per pursuant to the scheme of revision of
Sir,
pay
we
scale.
understand what is the new pleading you let us know, which requires a reply.
Lordship.
What is the additional ground in over and above what they pleaded in the writ petition?
Lordship, their allegation is that I have conferred increment without having that degree. That is not the issue, my lord.
Sir, we understand on merits, that's a different thing.
Lordship.
What submission do you want
Because
of reply?
Because here there is some observation has been made in the order by learned single judge, my lord. That was in my writ petition, my lord.
In my?
Writ petition which was filed before the single judge. That, my lord, he was the.
So they have come out for expunging of these remarks.
Lordship.
So what objection do you have?
Lordship, I have no objection because Lordship kindly.
Yes, UDA. Do you represent the UDA?
No, I'm the.
Then you are the UDA, yes.
Yes, I'm the writ petition that writ petition, my lord.
Yes, the action of the UDA is definitely questionable.
My case before the
they are not on the merits. They are only for expunging this observation. So do you want to have to say anything about that?
It's I leave it to Lordship, my lord, because that was observation made because he entered in the merit without having any authority, my lord.
That we understand.
Lordship will kindly
let learned counsel argue.
Lordship.
What reply is required to this?
Lordship, kindly turn to page 1.
This is a self-contained observation of the learned single judge.
Yes, because 145 is there, his letter, my lord. Because
Let's
of
see.
that, my lord, 145.
We'll ask the learned counsel what business your UDA had to write these letters.
Yes.
He considers himself to be a big shot or what?
Because of this letter, my lord, I subject to the show cause notice, my lord.
Yes, madam. Why we feel that he should be sent home. We'll rather take this upon ourselves.
My lord, he was just carrying, he is UDA. He is supposed to carry out the orders from the governing body, my lord. Governing body wanted him to go into the details of.
Let us see which letter is there, which the governing body issued to this UDA that you provide us this information. Or suggestions rather. What he has done? He has suggested.
He provided those papers.
Read the letter, please.
My lord. Page 145, my lord.
Yes, in view of the above facts of anomalies, it reveals that present position of Dr. Mala is violation of service rule as per guidelines. I request you to offer your suggestions. Who is he?
My lord, that I can understand, my lord. But
we are putting you to notice why this man should not be subjected to disciplinary inquiry. Ask him.
He is subjected to.
All right, let him
And
face the music.
disciplinary proceeding also, lordship will see in the last page, my lord.
Yes.
It is at page Annexion 9, page 223, my lord.
Yes.
Disciplinary proceeding was conducted, my lord.
Should be done.
my lord, there it was found that he, my lord, nothing against him was found. And therefore, he was exonerated, I mean, from all the charges. But
So we
my
should
lord,
feel
there-
happy at that.
my
We will set aside that exoneration right now.
My lord, that will be too harsh for, my lord, lordship will see the director
You
has.
tell
also
us what business this man had to write this letter. He has disrupted the service career of a professor. He is a clerk simply.
My lord, perhaps, my lord. he
We'll
is not-
impose cost then. All right. We'll impose cost while dismissing the pay. What do you say? 50,000 cost on this man.
My lord, that will be too harsh, my lord.
That will be the only justified outcome in this matter.
Oh,
He
my lord.
considers himself to a big shot.
If
Then
I-
all right.
If I may submit, my lord.
Yes.
My lord, the director of education.
For
has-
considering your appeal on merits, we direct you to deposit peremptory cost, 25,000 rupees.
My lord, that may not be possible, my lord. He's a small, in that case.
He
my
is
lord,
a
I
big
withdraw-
shot.
I withdraw the. application.
Yes. Counsel for the plaintiff gives liberty to withdraw the writ appeal, hence the same is disposed of as withdrawn.
Matter number 19.
Taking was probably upper hand.
This was item. May it please your lordship.
Yes.
In this matter, record was called for and it has been received by this honorable court. As such, it is fixed, it may be fixed for hearing on.
Well, all right. The writ appeal, we'll admit the appeal and list it for hearing. The writ appeal is admitted. The parties are duly represented. List for hearing in due course.
Matter number 21 and 22.
Lordship, in this matter, the department has already initiated for compliance of the order dated 2/11/22, Lordship. And
Which order?
Lordship, the appeal order, 2/11/22 in WPC number 3142.
All right.
And
What was the
28
direction given in that? That inquiry to be held.
Yes, Lordship. So already the director has written to the deputy commissioner and sought report by conducting an inquiry by the circle officer of that concerned area, Lordship.
What is
regarding
the result?
Status.
How, why
Lordship,
does it
not
take
yet-
so long?
Not yet, Lordship. And on 29, the personal hearing has been fixed, Lordship.
What do you say, sir?
29/5.
Let them complete that proceeding. Then Council MS M. Bhattacharjee submits that the inquiry as a consequence to the directions given by the learned single bench has been initiated and the hearing before the deputy commissioner.
Hearing, no, Lordship, before the
Competent authority.
director, Lordship.
Before the director
Yes, Lordship.
is fixed on 29th of May.
29th, Lordship.
List after 2 weeks so that the proceedings of inquiry can be brought on record.
Deeply obliged.
Right.
Matter number 23 to 25.
Yes. They are requiring BC. Only for that. In this also the same counsel is there. So you open the proceedings. Madam, you are appearing in these matters also? Are you appearing in these matters?
I'm appearing in item number 16.
Not in
Through
21 to 23.
No,
23
my,
to 25. No. All right.
the senior advocate, the learned senior advocate, Mr. Datta is appearing in
All right.
20.
I'm there. Yes, very well. Yes. Yes, please. Yes, Mr. Malgopal. Please. Yes. You could finally land in Guwahati after significant efforts, it seems so.
I've been coming to the other courts incidentally.
Yes.
Please, ma'am. My lord, I start with this writ appeal number 10. There are 3 appeals, 10, 11, and 12.
10. No, 79, 80 and 81.
That is Yehoshua 2.
There's 11, but 71. I think the number.
Item,
25.
item 25.
25. They mean green numbered after being transferred here. That's right.
25 is 81.
81. Yes.
Please. Now, this matter pertains to
Non-declaration of result of
that
recruitment held in 2003.
Three.
For what justifiable cause?
Yeah.
That you have lost the records.
That's exactly the question.
So the persons who participated, they should suffer for the incompetence of the officials.
Let us examine that
Very well.
from the facts which will.
Sure. Please go ahead.
So according to them, they faced the interview sometime in 2003, 2004. They are supposed to have been selected. Later, since it was not, nothing was forthcoming.
Rather, to put it in correct perspective, the result was supposed to be declared.
That's it.
Right.
After that, from 2004 up to 2016, no movement from their side. The so-called selection remained static.
Dormant. Yes.
Then certain intervening circumstances came into the picture.
Fresh recruitment notification.
No, before that. 13 different posts were advertised in 2003. We are basically concerned with the class 4 posts. So initial writ petition was filed pertaining to the undergraduates. We are not really concerned with that. The single judge in 2015, on the basis of writ petition filed in 2013,
yes,
passed certain directions. May take you to the single judge's judgment.
Yes.
Page 75 and 76, 74 to 76.
Yes. No, it's not at 7. Yes.
I'm just coming to the relevant last paragraph. May I read it, please?
Sure. Carry on.
My lord has got it.
Yes.
After considering the submissions made by the learned counsel for the parties, and on consideration of the materials available on record, this court is of the considered opinion that the litigation concerning the posts of UGTs has got nothing to do with the present petitioner. I'll just stop here for a moment.
What's that litigation about?
As far as the undergraduate teachers are concerned, they tried to quote that they had approached this court.
All right. So as to get continuity in
that's
litigation. Yes.
So the court said that has got nothing to do with your case. They filed it in 2004. It was quashed in 2007.
Right.
And in 2010, certain modifications. So they said nothing to it.
So,
but
no connection at all.
Yeah. Then they say,
yes.
However, surprisingly, the respondents are yet to publish the result of the petitioners insofar as the post to which they have applied is concerned. The respondents are therefore directed to forthwith take steps to publish the result of different categories of posts to which the petitioners have applied and thereafter make appointments to the selected candidates. Such steps should be completed as early as possible, not later than 2 months from now.
So this, your contention is that for the so-called recruitment of 2003 and the non-declaration of the result, This writ petition came to be filed in 2013 with a prayer to consider the delay explained because there was some litigation going on. All right.
But in this petition, we were not parties.
You were not a party.
No.
Then who was the party?
This was again some other of the employees, maybe class 4, who had filed the petition.
Yeah, but the state was a party.
State was a party.
Then?
But as far as the impugned judgment which pertains to other petitioners are concerned, that is different. I will just come to that.
No. You are not a party. How? Clarify that. Sir.
No. State has to be a party. I am saying those who are aggrieved and who are before this honorable court now, they were not a party.
They were not the petitioners in that petition.
In 2013. They waited for the outcome of that in 2015.
All right.
And 1 year thereafter,
they filed their own
a petition in 2016.
All right.
That's all I'm differentiating.
Okay.
State has to be a party. Then, my lord, after this direction was passed, we were told to make the publication of the result.
Probably they are taking advantage of the fact that in the order there is a reference to your advertisement number 1/2003. This post was also a part of that advertisement.
Yes.
All right.
Now, my lord, pursuant to this, on page 78, can I get a clear copy?
Yes.
May I read it, madam? The relevant portion. They have done the publication as directed by the court. As far as class 4 is concerned, it is further notified that in accordance with the department notification order number such and such.
You're reading it?
I am reading the top left side, madam.
Right.
Is it clear, my lord, your lordship copy? I'm having a smudged copy, unfortunately. I'll place a clear, your lordship has got it?
This document only reads result of so and so is declared in compliance of the High Court's order.
Right. So the last paragraph is, it is further noted that in accordance with the department notification dated.
No, there's no such paragraph in this order.
That is the second paragraph.
All right. That's a newspaper publication.
Yeah, newspaper publication.
Yes, it is further notified. Yes.
Right. So here, it is further notified that in accordance with the department notifications dated 3rd of August 91, the grade 4 posts were
directly appointed
from amongst the landowners.
Yes.
And therefore appointments will not be made based on the interview results. This is the publication. This was done in 2015 itself. So we had various documents starting from 1971 up to 2018, stating that these landowners, what is the role of the landowners? Because especially in Nagaland, it is the people who own the land, not the government. So even if the government wants land, they have to purchase from the people. That is the idea. So when they are donating land, they donate very liberally for these educational institutions, etc. The state, as a matter of gratitude to them, because no consideration passes, that they are investing all these land for our purposes, one person can be given one employee. So they decided as far as
policy of the state.
Well,
is there a policy?
That is a
place?
policy.
All right.
There's a clear-cut policy. I'll come to the policy also.
All right.
So on the basis of this policy, this was being continued right from 71. There are notifications of 91. There are notifications of 2000 also. So it continues. So it was precisely for this reason that this was treated here.
You had already filled in the posts in the meantime.
My lord?
The posts advertised in 2003 had already been filled in by that process.
I'm coming to that.
That's what you read right now.
I'm coming to it. These are meant only for them. After this was published in 2015, we are now in 2023. Nobody has challenged this order. All those persons who are parties who tried to take the benefit of this also did not choose to challenge it. because they were conscious of the fact that unless you're a landowner, you can't get this particular appointment.
Okay.
So these publications have since become final. This is my first submission.
Okay.
I'll answer your lordship as to how this was filled up or not filled up.
But while we are on that, please read that para of the impugned judgment, that part of the impugned judgment, wherein this fact has been argued and considered.
I am talking of the judgment at page 75.
No. You said that this publication, this declaration became final as it was not challenged. So this argument must have been raised before the court which decided the matter in the writ petition now. In the order which is under challenge. This argument must have been made.
Yes, para 6, page 107, para 6.
This argument, Mr. Balgopal.
Yes.
This must have been made before the single bench.
That is there at
Let's
page
see how it has.
107,
Yes.
para 6.
Yes.
Learned counsel, referring to annexure K1 of the writ petition, submitted the Director of School Education had in compliance of the court's orders passed in such and such and other
Yes.
connected writ petitions, the result of successful candidates of grade 3 and other categories of teachers had been declared in the Director of School Education notice board. However, in respect of grade 4, the responsible authorities, by following the government notification for 5th August 1991, the grade 4 post had been directly filled up from amongst the landowners.
All right.
And
Yes.
hence appointment was not made on the basis of this. Now, my lord, now I'm coming to the next litigation, because we have a series of litigation. The second litigation is this group, which was just waiting for the outcome of the petition filed in 2013. They had a ray of hope in 2015, because apparently it looked like the judgment, they could take advantage of it. But when the government gave this publication, then they realized that there again, they may have to challenge it. So in 2016,
they filed the writ petition.
For the first time, they filed this writ petition.
All right. Can we look at the prayer clause, please?
Please, madam. Page 53, madam.
Yes. No reference to this publication?
No.
In the petition?
Not at all. I'm right. Am I right?
No, there is.
Yeah?
There is.
There-
Para 11. Mr. Balgopal, you are not prepared, seems so.
No.
Not properly briefed.
I'm prepared, but I was going in a different track.
Para 11.
Page 8, page 2, page 51.
That's it. That your humble petitioner submitted the correct, my lord, is a general advertisement, and the government has issued a modified recruitment rules. Bound by record, the advertisement will be given to landowners and enforceably the DSA recommends upon such, and it is unbecoming of the respondents to flout the actions of the legally
Yes.
constituted all by whims.
All right. Yes.
Right. Now, my lord, after this litigation is over, when they file this petition, the court passes another order. That order is relevant, madam. That is at page 105.
That is what the order we are reading.
Correct.
Yes.
We are on this.
Yes.
Now, the relevant portion of this order is after going through all the facts, whatever has taken place, then they say, para 10, my lord, page 108.
Yes.
Although it may be open for the state respondents to adopt any criteria of selection for the purpose of appointment of grade 4 post.
Yes.
Yet, in the considered view of this court, once the advertisement is issued for selection of grade 4, whatever may be the criteria of selection adopted by the state government, yet in all fairness, it is imperative that the selection made in pursuance of the advertisement dated be published for the information of candidates who had participated in the selection process. Next para, my lord. Although there may be substance in the contention raised by the State Council that the writ petitioners have not been vigilant about their rights and there is considerable delay in approaching the court, yet in view of the decision rendered by this court on 29th April in writ petition of 2013, along with connected with the writ petitioner, wherein it has been directed the respondent authorities to declare the results held in pursuance of the advertisement, I also deem it appropriate to allow these writ petitions by passing similar directions that has been passed on 29th April 2015.
Yes.
So it is virtually repetition of the earlier order which has been passed, craving reliance on that particular order. But again, I don't see any reference to that publication which your lordship was saying, which had taken place. That's why I said I didn't find it in the judgment, but in the pleading thread. Now, after this order has been passed, my lord, we'll have a quick look at page 96 to page 101.
Yes.
These are the notifications issued by the government from time to time. Towards the end, preference will be given to landowners. The next page, 1984 notification. Then 1991 notification at serial number 5, and so on.
Yes.
Also, in next page at page 100, 2000 notification at page 101. They are saying consideration should be given for the landowners. So these are the various notifications. None of these notifications have been under challenge either, nor the policy of giving it to the landlord. Now, my lord,
yes,
faced with this particular position, at that time when this order was passed, the government was of the genuine belief that these results may be with them.
Maybe
Available with them. Because they asked the council, can you comply? They said yes. Then began the search.
Okay.
When they started searching, they found out that none of these earlier records of 2003, 2004 were available during after post 2016, maybe 2017 or 18. So since the time granted was specific, you have to comply within such and such time. The government did not say that we will not go ahead with giving these details, because if the details are there, we have to only publish. So the state was taking time, at least on 3 occasions.
Compliance.
Give me 2 months, give me 3 months. Ultimately, they said, we'll give you 45 days. So confronted with this position, when they did not give any further time, it was decided to refer the matter to a SIT to find out exactly what happened to these documents. We also should know where it has gone.
Yes.
I am aware of this because when they told me, I said this has to be investigated. We should know our document where it has gone.
Yes.
So the details of the SIT for our purpose is on page 141. More particularly at page 140.
Yes.
My lord has got that, my lord. This is the SIT, senior officers, principal director, school education, a member and another member.
Yes.
Now, this is their report. May I read this, my lord? This is relevant.
Yes.
Report on findings and suggestions of the SIT with regard to the results of the selection held for grade 4 posts in terms of advertisement dated 7th July 2003. The issue was deliberated by SIT constituted on 3rd March 2020 during a series of meetings held on such and such a date to ascertain the facts of the case and on search of results from various districts, particularly the missing 9 establishments. The SIT wrote, discussed and met some of the officers posted in the missing establishment, deputy commissioners, ADCs, district DEOs, SDEOs of various districts. But in spite of the best efforts, the SIT could collect only 2 establishment results, Long and Nokla, of the 9 missing establishments, which is Annexure 2 as Annexure 1. Other missing establishment results could not be collected as there was no record of conducting interview from the concerned office, nor do the concerned officers currently at the helm could furnish stating that they have searched all the files and registered in their office. There is no such record. Therefore, SIT recommended the following measures. Department may inform the Honorable Court the difficulty faced by the department. Collect such results which are unavailable. This word unavailable is relevant. I'll come to that. Department may seek the Honorable Court to grant permission to declare publish the available results. School education and audit. So this was the finding of the court concern, of the SIT. Now, since these things were not considered by the court, that is, the documents are not available. Thereafter, the government thought it fit. We will file a review petition.
Yes.
That is, these are the difficulties faced with us. Genuine effort was made. We could not get these documents for these reasons. So we filed a petition.
Yes.
When we filed this petition, my lord, we also brought to the notice of the court.
Yes.
Just keep it. I'll come straight to the review order. At page 158, para 9, that is a verbatim repetition of the
Repetition
earlier
of the
order. Of the earlier order.
original, yes.
Correct. Then, my lord,
yes,
kindly come to para 8. Para 11. First, I'll come to para 11. In the instant case, there is no question of misconception of fact or law by a court or even an advocate. Rather, what has been contended and urged by the applicant seeking review of the judgment and order in question is that the record of the selection held having gone missing from the department be accepted as sufficient cause for review of the judgment and order passed by the court. In my considered view, relevant records going missing from the department concerned, resulting in the incapability of the respondents to comply with the orders passed by the court, cannot be termed as sufficient reason requiring review of the court order passed in the writ petition, inasmuch as it was not the contention of the review petitioner's respondent authorities in the writ petition that the record of the selections held in pursuance of the advertisement is no longer available with the department. I read out in that SIT report, they say precisely this. It is no longer available with the department.
Yes.
Then added to this, my lord, because each judgment was giving us a hint on what you should search. So we were just actually finding out from that. Then it turned out that we got into various other records after this. Then we realized that there are 3 types of records maintained by the concerned department. One is called category A, one is called category B, and one is called category C. So A and B would be preserved for even up to 25 years. which is less important than that. They will basically contain very important document. That is C. As far as C is concerned, they keep it only for a period of 5 years, extending up to another 5 years, 10 years. So the record pertains to 2004 or 2006. They filed the petition in 2016, and then the search started 2 years later. Now, how do we know that this is our particular document comes under C category? That is mentioned here, my lord. Page 169. I am directed to refer to your letter dated on the subject above and say the document referred to in your letter may be categorized under class C as per classification of records.
Yes.
So this is class C. Then, my lord, kindly turn to page 170. In 170, in the second paragraph, at para C, my lord has got it. Class C means file documents of secondary importance may be prepared for a limited period. This category of files shall be preserved for a minimum of 5
Where
years.
is subclassification? What is, how do you define what is class A, class B, class C?
How do we define, my lord?
What are the three classes about?
A, B, and C.
So what does A comprise of? What does B comprise of?
Let us read that for a minute. Class A documents, that's the top, my lord. Class A documents means any document files having historical values, importance for frequent reference. These are to be preserved for indefinitely. The original all files, so it can be reviewed after 25 years. Now, class B means files, documents which contain orders and instructions, etc., having no permanent importance and are not likely to be required for reference after 10, 12 years. This category of document shall be preserved for 12 years.
Right.
Class C means files, documents of secondary importance, which may be preserved for a limited period. And this category of files, documents shall be preserved for a minimum of 5 years and not more than 10 years. So this being the position, my lord, taking all these factors into consideration.
Read para 2 of this memorandum.
My lord.
Read para 2 of this memorandum.
Records of any category should not be correct. That I'm not in any objection. Records of any category should not be destroyed without furnishing, sorting. All that is right. I'm not disputing that a procedure has to be followed. All that I'm not disputing. I'm only saying, with respect, that this category C is not a category by which has the importance of either category A or category B.
Yeah, you're right. Even in judicial services recruitment, the records are not maintained beyond 5-7 years. That's right. The records are weeded out.
So, in fact, the learned judge had referred that there must be some procedure of preserving documents, etc. That is how actually the search begins. Then it comes out that we have 3 types of documents. Then we wanted to know to which category this belongs. So they have themselves written that this belongs to category C.
Normally.
And if it belongs to category C, generally 5 years, may extend up to 10 years.
All right.
So this is the phase as far as the documents are concerned in this. Okay. In the light of all these facts, my lord, when we were moving from court to court, facing the same problem, because court is also not on this question that whether they are entitled to be appointed or not. That was not the issue, actually. If you see the various orders, they are saying, why are you not declaring the result? That was the main grievance. Genuinely, we can't say anything about that. But the state also had an unfortunate problem like this. And later when we investigated into the whole thing, then we realized perhaps this coming under this category, maybe we may not be able to retrace the document.
Okay, very well.
Yeah.
Yes.
Pursuant to this, my lord, we filed the appeal. Next, before this court. Now I come to the legal point because the factual position is the same everywhere. So I will just take your lordship to a few pages of.
Your an admission, Mr. Balgopal, shows one judgment which, as per you, is the best. We are on admission of the appeal.
Yes.
not final hearing.
No,
Shows
my
one
lord.
judgment.
Finally come to page 17. Famous judgment of this Hanuman Industries.
Yes.
I just, which is in
Delay in
bold.
approaching the court, all right, that there are umpteen number of judgments on that.
Yes,
All
until
right.
judgments are there.
All right, you can take your seat. Yes, Ms. Datta, please. Tell us why your clients approached the court after 13 years.
Now, my lord, your lordship may kindly see.
Yes.
Will I be putting your lordship in a convenience, requesting your lordship take item 79 of 2023?
Then
There's
he
the
has
first
argued
page.
from 81. You have to refer whatever you want to refer.
My lord.
Read from 81.
These are all the same, my lord.
Yes, so 81 is there in our hands.
My lord, I tried.
Is it a dispute? Is it a disputed fact that the writ petitions were filed by your clients for the first time in the year 2015?
Yes, yes, it's a correct position.
It's a correct position.
Now, your lordship.
And yet, just hold on, sir.
Yes.
Despite referring to that advertisement wherein they said we are not making any recruitment because posts have been filled in, was there a prayer in your petition that this should also be quashed? Read.
Your lordship kindly see the advertisement first.
Yes, please. 53.
Advertisement, your lordship will find.
What was the page?
In page, my lord.
78. Read. $78.
Not 78, my lord.
Yes, it is 78, sir.
In
Annexure K1.
my lord, and 81 of 2023.
Yes.
your lordship will
Yes. Just after the result, annexure K. Annexure K1 you may see.
71 is
78.
71. 78 is not that. Annexure K1.
Ms. Balgopal, please, can you pass on the document to your senior
I'm
counsel?
talking about the advertisement dated 7/7/2003.
This is page 56.
78.
Advertisement.
No, not the advertisement, sir. The declaration of result in newspaper.
That's
The declaration that we will not be making recruitment.
That is 78 itself.
78.
78.
The question is, my lord, from the advertisement I will show, they have said that preference will be given to the landowners. It is not that they.
Sir, will you please read that?
That I have seen, my lord.
Read please once again on our request.
It is further notified that in accordance with the department notification order dated 5/8/1991.
The grade 4 posts were
being-
ever been directly appointed from among the landowners. Hence, appointments will not be made based on the interview result.
Therefore,
This
my
was never questioned.
Yes, it is correct. Now, the question is, what is the advertisement? Now, if your lordship kindly see the advertisement, whether that embargo was there or not.
So that we'll see later. First, tell us the reason for not approaching the court for 13 years.
Now, your lordship has seen the similarly.
There are
situated
n
persons.
number of recruitments and the procedures provided that the record pertaining to a recruitment will not be preserved beyond 5 years. You're absolutely right in saying that we had no reason to preserve the record beyond that. And that is why the delay goes to the root of the matter. You were not the litigants in the first round of litigation.
Yes.
They were the undergraduate teachers.
That's very
You don't draw any parity from them.
Now, in that case also, my lord, those persons were similarly situated.
Immaterial, sir. We are not bothered about those results. They may be agreed, they may not be, we are not bothered. Here there is a specific objection. 13 years satisfies on that, please.
Now, yes, there is a delay of 13 years. My lord, I accept that position.
Then there is no force at all.
but
They
the
are
honorable
absolutely
court-
justified in destroying the results.
But the honorable court has said,
Yes.
since, my lord, those persons who are similarly situated.
Similarly situated,
They
the
were-
court has said UGT has no parity with your clients,
But,
undergraduate teachers.
but in view of the same advertisement.
Maybe,
dated
maybe.
7/7/20.
They were litigating right from 2004. That is the difference.
No, but then, my lord, relying on the advertisement dated 7/7/2003.
Yes.
My lord, they came before this honorable.
They
court
came
and-
because they were in litigation. In all probability, their results, their records must have been preserved because the matter was sub judice.
No, the government did not say in this, affidavit.
All
They did
right.
not say anything, my lord.
Admit stay.
Public. I just want to mention your lordships. I'm told that one matter of ours has been passed over. item
Yes,
number 16.
yes.
And in this, my assisting counsel, she had gone to Jerusalem. She was only prepared.
Okay.
So kindly keep it sometime next month.
The council over there in Kohima, you have to make a request to them. Madam.
Item number 16.
Unmute her, yes. Then the Advocate General is making a request for some accommodation.
Your Lordship, let the date be fixed.
Date be fixed, yes, we'll fix the date. When?
Towards the end of next month, subject to your lordship.
End of June, what do you say? Then the Advocate General might be following his associate to Jerusalem, for all we know.
Your Lordship, I'm mentioning on behalf of my senior.
So what date do you want, Madam? Learned Advocate General has requested for last week of June.
Your Lordship, I'll call my senior. 1 minute.
All right, let her call her senior.
My lord, these three matters, can you?
We'll
fix the
list
date?
them for hearing in first week of August.
Man.
Yes,
Towards the end of August.
end of August. Is there some auspicious, Mr. Balgopal, is there something auspicious in the end of the month?
No, in fact, my
You have to travel.
diary is such only because of that.
Last week of August.
I'm deeply aware.
First Tuesday in the last week. That would be 29th of August.
Please, ma'am.
All right. Yes.
All right.
And you talk to her and what date is to be fixed. Please finalize. Yes. Let the court master know. All right.
Item number 26.
26.
May I please, your lordship?
Yes, please.
Your lordships gave us a relief by order dated 27/4/23, which your lordships will get at page 313. It relates to those static small stalls without any radiant
Yes.
response. Your lordship said that status quo as on that day will be maintained.
But the railways have concluded that inquiry and there was one matter, Mr. Chaudhary.
That was another.
That was another.
That was another.
All right.
Your Lordship had directed me to file an affidavit. Our Lordship, I could not file it. So
I'll just tell your lordship what has happened.
Yes.
27/4/23, your lordship passed that order.
Yes, status quo.
Status quo. 28/29, no problem. 30th, they come, draw the shutter and put a lock.
Then probably you filed contempt.
I am filing this additional
Affidavit
affidavit and application
Okay.
for your lordship's kind
There
consideration.
was similar matter in which the identical order was passed
yes, yes,
and probably the railways. All right, that was the matter where in 7 days you passed that order.
yes, yes,
Final order was
yes,
passed.
yes, Lordship.
So what is the status in this case?
Lordship,
He took time.
No,
He has not filed
Mr.
it.
Goswami,
I
right
can
now,
understand his
right now he's too engrossed in a NIE appeal.
I quite
So
agree with that.
his wholehearted effort is into that matter.
The board has been issuing circulars saying that maintain the status quo of 2019 so far as these stalls are concerned, minor stalls. Only in Lamning division, this is happening, otherwise rest of the country, no violation of the status quo as wanted by the railway.
Do you move your application? We'll take it up next week. You're filing some application today.
I have filed this application, my lord.
When?
That was filed on 4/5/23 itself.
Additional affidavit on behalf of the plants.
Yes, sir.
Yes. So he has to respond, sir.
Yes,
He has to
in
respond.
time before
fact,
the
Lordship,
other first
I received
affidavit,
my notice
it
today,
has
I'm
not
very
come.
thankful.
Please,
And they have
We'll give-
accepted
we'll
my
give him
money
4
for the
days.
entire year, 31st of March we paid.
We'll give
And
him,
we were running, we first affidavit, we showed the photographs right up to 24th. That's why your lordship passed that order of 27th, maintaining the
Chaudhary,
status quo. So at least.
yes, tell your officers not to be so harsh.
Lordship,
These are small time vendors.
Small vendors and.
Lordship, I will definitely pass on the message, Lordship, information, Lordship, but let's see what's the stage.
The
Then-
stage is that it is closed.
At the place, Lordship.
He has to
Yeah,
file
yeah,
the.
he can take time and
Mr.
he
Chaudhary,
can ensure. me.
Praise for and is granted 7 days further opportunity
And
to
he
file
can-
the affidavit
Lordship.
on behalf of the respondents.
I'm sure he can ensure that your lordship's order.
List
My
on,
seniors, whatever my senior has submitted.
list on 29th,
I'll convey
29th.
today.
29th.
Of life. This is not done really.
Item number 29.
Development.
Mm.
Wait, please, your lordship.
Yes.
Lordship, in this matter, lordship, I prayed for 4 weeks' time to file our reply, lordship.
Well, we have filed an affidavit on behalf of the respondent number 3, man.
The council for petitioner prays for and is granted 4 weeks time to file an affidavit in response to the government's made in affidavit filed on behalf of the respondent number 3.
Man.
List up 4 weeks.
Item number 43 of supplementary list.
May I please, my lords?
Yes.
Lords, this is a condonation of delay application wherein 31 days delay has occasioned, your lordship, in filing the writ appeal against the single judge order, your lordship.
Do you have to serve the other side? You are here
Lordship,
for the respondent. What do you say to delay?
Lordship, we will be filing our objection, Lordship.
Then Mr. Council, Mr. So and so appears on behalf of the respondents in this interlocutory application filed seeking condonation of delay. He prays for and is granted 10 days time to file an objection against the prayer for condonation of delay. List of 10 days.
Much obliged, Lordship.
I'm so great. Yes. Done? Yes.
Item number 30 to 42, part heard matters.
Senior Advocate Mr. Mishra is not here.
Your lordship, the judgment has been I found. Mustaqim versus State of Rajasthan.
No, that is not Muskim. Actually, the judgment we are telling you on 27 is Mohammed Hafiz.
My lord, as far as your lordship, I did the research.
Muskim is on a different point.
Different footing.
We taken out one judgment from Rajasthan.
But my lord, your lordship, that proving our disclosure statement, your lordship, I was doing research, your lordship has passed one judgment.
There are not
Relying
one,
upon-
there are more than one.
My lord, yes.
Relying on Mohammed Hafiz. That is the judgment of Supreme Court.
Dauram, yes, your lordship.
Yes, Dauram is the judgment.
Yes, Dauram is the judgment. And my lord, I've got the link evidence judgment also. I will please let us find it out.
But we have a query to put actually, and we would like Senior Advocate Mr. Mishra to be here. Is he there on virtually through VC?
No.
No. Why?
My lord, on Friday, he was diagnosed with blockage in his intestine.
Oh.
So he immediately went to Calcutta for further investigation.
Oh, okay.
I can convey him your.
No,
query.
then don't bother him. Mr. Chaudhary, there's a very serious question which we have to pose. And your response will be very vital. Charge file, charge. Volume, whatever the volume is.
Volume.
And can anyone help us out with the charge sheet which CBI has filed in relation to these very allegations of defalcation?
Well, my colleague can be doing it. No.
Anyone is having the charge sheet, please? Mr. Chaudhary, read the charge.
CBI case.
Charge of this case.
Lordship.
Read.
Lordship,
Read the charges, please. NIA Act. Come to charge number 16.2. No, this is the charge sheet, sorry. Where are the charges?
charge lordship.
Charge framed has been on volume 1,
Just hold on. Volume 1.
volume 1, page number 4.
So the argument was raised, but there is something more deep to it. Read the charge. Forget the firstly. Forget secondly, thirdly, fourthly. Yes, fifthly.
That after forming terrorist gang,
Yes.
PhDJ, in 2004.
Forget that line also. Siphoning and defalcation of government funds, right?
Yes,
Through Mohit Hojai.
yes.
He was a public servant at the relevant point of time. Come, proceed further. Paying money without supply or short supply of articles.
Lordship,
So that is 409. Making the rate of supplied articles more than double market by preparing false bills, vouchers, delivered challans. 467, 468. Okay. Mr. Chaudhary.
yes,
There is no dispute that NIA has the power to investigate these offences.
yes, Lordship.
It did not.
It did not.
You propose a charge without putting in those sections. So the accused are not being tried for these sections. Yet you ask the court to record a finding on that. Finding is there, defalcation, falsification of records,
Lordship,
without there being a conviction on that aspect.
yes,
Is there a conviction for 467? Is there a conviction for 407-9? Is there a conviction for section 13 of the PC Act?
No.
Right. But the findings are there.
and
So now, just let us contemplate that those findings are declared to be bad in this appeal. What would happen to your criminal trial by CBI? Is it not a case of double jeopardy? Two trials on the same allegations.
yes,
Then coming further, your IO comes very conveniently and says, this part of investigation we handed over to CBI. So if this part was not investigated, how can the court record a finding on that? So there is an investigation without recording, without investigation, because you present the material to the court. This is the defalcation. This is the short supply. This is the misconduct. There's a charge framed to that effect. And yet, misuse, that is the CBI, FIR, misuse of official position, cheating, etc. Mohit Ojai, Jayant Ghosh, Karuna Saikia, so and so, so and so, so and so. So then, if you are not investigating those allegations, then what business did you have to file a charge sheet for the same allegations in this case? And that too without investigating. And over and above that, what will be the consequence
the case.
if we record a finding against the NIA in this appeal on these issues? What will be the fate of your CBI case? Because we have been called upon to do so.
Yes, sir.
Then
That is what.
Hmm?
So,
So your case of funding, Mr. Chaudhary,
Lordship.
is based totally on this allegation that the funds meant for development of the Hills Council, they were pilfered, ciphered, or defalcated. So that gives rise to by preparing fabricated documents.
Lordship.
So that gives rise to 4 offenses. Number 1, 467, number 2, 468, number 3, 409, number 4, 13(1)(d) of the PCI. Your agency is empowered to conduct investigation on that. We read the provision section 8.
I have seen.
Your IO says no investigation. We gave it to CBI. The trial court says, yes, that part of the case is not being looked into us. Then why these findings? If there is a separation, there is a division of issues to be decided, leave these issues aside. Why are we supposed to decide those? Ma trading. Everywhere the reference is there.
Yes.
Ma trading. Jayanta Ghosh discharged. No evidence. Is it not a case of double jeopardy then? In respect of Mart Trading, MS Loknath Trading and Messrs. Jeet Enterprises, owned by Debashish Bhattacharjee, but managed by so and so, it has been recommended to the NCL's council to take steps for recovery of excess amount. So it's just a case of excess amount being paid, not of defalcation as per CBI. That part goes. CBI says no, not a fit case for trying these people. Trial is being done of Mohit Ojai, Karuna Saikia, Jivangshu Paul, Uttam Fonglosa and Dilip Fonglo. No RH Khan, no Jivangshu Paul, no Devashish, no Sandeep Ghosh. With a positive finding for want of sufficient evidence to prove their criminality.
Then this.
Should we ask you to file a written submission on this aspect? Why not?
But on the face of it, Lordship, the same.
Because this is a part of the court record, court proceedings. We can call for certified copy.
Lordship, in fact, that have to. That is with us.
No, we'll get it, don't worry. So then,
that needs to be addressed, Lordship.
all right, address on that.
No,
Okay.
I have to see that, Lordship. Because.
Pass this chart sheet on to Mr. Chaudhary. Now, this is all right. We have just given you out what
Yes.
was working in our mind.
Yes. Lordship, that's.
And Mr. Borgoin, though we are not having Mr. Mishra today with us to benefit us with his arguments, we are having VK Mishra with us. Read. No Mr. DK Mishra, but VK Mishra is here. Read paras 15 onwards. What we were telling you. 62. Yes, Mr. Chaudhary, you continue your arguments. On this, you will address tomorrow. This is we have given you the homework.
Yes, huh?
Yes.
I was to address your Lordship on Harris Khan itself today.
Yes.
Lordship, can I keep this?
Yes. You have got extra copies. Who has given this chart sheet? You've got extra copies. Get photocopy made. Get a photocopy done immediately.
May I read it, my lord?
No, no, this is for your consumption.
My lord.
वो निकाला है ना? You've taken out the book. One. Yes, RH Khan. You argue
Yes. Lordship.
whatever, for whatever worth the things are.
I would, Lordship. So far
First
as-
and foremost, you will have to satisfy us on that last statement of CDAC. 18 crores deposited in your accounts, frozen by CBI. So the amount defalcated, the amount, whatever you have come out, the maximum, more than that is already lying in the funds. How do you explain that? All right, proceed. What do you want us to read?
So far as Lordship RH Khan is concerned, Lordship,
Certified copies to be called.
I would take your Lordship to the evidence of PW 30.
PW 30?
Yes.
Paper book?
It is in volume 1,
Yes.
page 155,
Yes, please.
where
Pranesh Barbosa, yes.
he states about the documents and his deposition would reveal that, Lordship, what I would not read the whole statement, Lordship, but he says that these are the documents by which these supply orders have been given, and these are all done lawfully as per the procedure. However, Lordship, at when the court put him a question,
Where? Page number?
uh, the at page 267, Lordship.
267.
It's very long.
That's a long
It's very
statement.
long.
Yes. Yes.
He categorically states that court put him a question that do you receive the article supplied to your office? He says no.
So there is a store assistant. He receives the articles. He is a dealing assistant.
Lordship.
That was the argument advanced by Mr. Chaudhary.
That is
How does it help you? I think everything, this is the witness who said that this much is the amount lying frozen. He is the witness. No.
no. Sorry. Is it?
Yes, sir.
Huh?
He has stated that amount is lying in the bank account.
Exhibit P, what was that?
Exhibit C, Lord.
C.
C.
Exhibit C. Take out that exhibit C, please. At page number? Where, which is the volume and which is the page? And where does it say so? Mr. Counsel, what's your good name?
Jad, I'm assisting Mr. Senior Counsel Jad Kumar.
Yes.
On the way.
All right.
Good, sir. Exhibit C.
Where is it referred to?
Not sure. Take care.
Yes. Which I shall do. We will take use of this.
So we will find that page 262, Lordship.
262.
Only one. Freedom to-
No, it's in the same statement, 262. Yes,
Let's see the statement showing the total fund received scheme-wide expenditure incurred from MCA, Autonomous Council. I am acquainted with the signature of PT Jaldo, who is submitted the exhibit C.
yes.
In charge of Deputy Director, Social Welfare
Exhibit C.
Department, Hamlet, Humanity,
Mm.
signature of OMG. That
Mm.
exhibit C shows that there are amount of about 19 crores lying.
Did you put this question to the IO, Mukesh? Was this question put?
No, no, it was not. That.
Please check. Check.
That's right.
And what is the page of exhibit C? In which volume is it?
I'll find out.
Yes, please.
Exhibit C.
Yes, exhibit C is the document.
PW 30 exhibit exhibit করা হয়েছে। এখান থেকে করেছে বাট প্রো PW 30 just
Anyway, exhibit C to
That's exhibit.
volume 2 to some.
C, I don't know. C should be exhibit of the by the court. Normally it defense exhibits it as exhibit defense. Exhibit D1 should not be, should be there. Yes, all right, you continue, Mr. Chaudhary. So you read this,
That Lordship, that the court has taken note that for that. Pointing out, Lordship.
but he is not the store in charge, you know. That's correct.
That
And above that, then you read above that. Just above what you read. Mostly he has answered. So the work is properly executed in the office of the deputy director, passed the bill for payment. So the office had done no irregularity, performed duties.
that has been his stand all through, Lordship.
So all through he has said so. You have not cross-examining him on this aspect. So now you get this finding, and what happens to your CBI case? There are both situations. If we give a finding against the accused, the CBI court will rely on that. Obviously, finding by the High Court on same issue. So this is.
It has overlapped each other.
Hmm?
It has overlapped each other, Lordship.
That's the task your IO has, the situation your IO has created.
On the court.
Why not on the court? On you. The effect will be on the prosecution, whichever way it goes.
Lordship.
But once you yourself say that we handed over that part of investigation to CBI,
The CBI.
then which part is to be considered here and which part there?
This automatically.
Is there any classification? Where the line stops, where the line begins?
No, definitely.
All right. Carry on.
May I take your Lordship to the deposition of PW 45?
Hmm.
But your Lordship will find at page 347 in volume 2.
Volume 2. Yes.
May I read it, Lordship?
Hmm.
I joined the Social Welfare Department on 9/5/83 on the Jatinga Valley ICBS project, Mahur. In the year 1986, accused R.H. Khan joined as CDPO at Jatinka Valley. Thereafter, he took charge as district social, something is missing, district social welfare officer on 18th June 1986. After that, he promoted so-and-so. With regard to the procedure for purchase of materials in the social welfare department, the office calls for tender quotations from the suppliers. Tender is not called for.
If the tender is not called
If-
for, he follow the approved rate given by the autonomous
Sure.
council. So this,
Now-
this is regarding that calling for the quotations and giving the work orders.
Calling for the now.
Read the last para on page
I-
348.
I'll come to that, Lordship. In 2008, 2009, tenders were not called by the department, but the department followed the rate given by the autonomous council. The requirements of materials are given by the district planning board. Exhibit 211 is the receipt memo by which 19 numbers of documents were handed over to the NIA on 16/6/2009 at 8:30 PM. 2111 is my signature. Exhibit 73 is the file relating to rehabilitation persons on the ICDS project. I've gone through the file and say that I've seen the file earlier in the office, and this file is related to issue of supply orders to the parties. This file was dealt by me and the supply order issued by the Deputy Director R.H. Khan. The practice followed in issue of supply order was as per approved rate and approved supplier. Lordship will kindly note approved supplier because I'll be coming to that part of the position, Lordship, where the validity of the permit had expired. As soon as it is expired, Lordship, he would not be a.
Is that document on record? That is
That is-
permit
that's a-
period had come to an end. There is
Yes.
an oral statement.
There is a document also. I will show.
Sure,
I will-
sure. Very well.
Carry to the auction. Mukut contract, 311 is the name. None. Correct. PW 28. 1.
Yes.
Exhibit 394.
Read what is it? Did you ask any witness that there was a procedure of granting permits to the firms? Normally it's not to our understanding. It's not a trading or dealing in food grains that you need a permit. The firm is required to be registered. What kind of permit is necessary to do business?
No, let me. 370.
Approval is a different thing. Approval is a different thing.
370.
Permit is not the correct.
For us. 390. 395. I'll take it up, Lordship. In fact, the other side had also relied upon that.
Sure. Yes.
And the explanation that was coming for us, that under the Guwahati Municipal Corporation, they had a trade
Registration.
license.
Registration.
Trade license, but trade license is something which is issued under section 180 of the Municipal Corporation Act. That also has a validity of only 1 year. Anybody doing business here within the municipal limits, they have to take a trade license. Lordship, if I got it, Lordship, volume 7 of the exhibited documents, 1513.
Yes.
Page. Lordship at 4, page 1513,
Yes.
this is a letter. And at 4, it says, all permits are valid up to
1 year.
31/3/2008
Yes.
and not further renewed.
Right.
And this letter has been issued sometime in August 2009.
Yes.
So they did not have a valid permit
Mm.
at that point of time, Lordship.
Okay.
I was referring to the deposition of PW 45 and 47, Lordship,
Yes.
in paper book volume 2.
Yes.
348, the last paragraph. In 2008, 2009, the tenders were not called by the department, but the department followed the rate given by autonomous council. The requirements of materials are given by the district planning board. Exhibit 211 is the receipt so and so. But the documents handed over to the MA on 16/6/2009 at 8:30 PM. Exhibit 2111 is my signature. Exhibit 73 is the file relating to rehabilitation of BPL persons under ICDS project. I have gone through the file and I say that I have seen the file earlier in the office, and this file is related to issue of supply orders to the parties. This file is dealt by me and the supply order issued by the Deputy Director R.H. Khan. The practice followed in issue of supply order was as per approved rate and approved supplier. So I was on approved supplier because by that time this validity had gone. The rate and the list of suppliers were approved by the council. Exhibit 212 is the file, so and so. This is not. Okay, I'll read it. I personally dealt with the file. This file is related to issue of supply order and approval of schemes. 2121 to 2125 are the note sheets in my writing. 2126 to 2112 are the signatures of R.H. Khan. By note number 2122, as desired by CM and CHILS, the suppliers Sharma Enterprise, Ojeng Singuin, Ma Trading, Borel Enterprise, supply orders were directed to be issued by note dated 14/11/2012. Two firms were proposed for issue of supply order. They are Ma Trading and Devashish Bhattacharjee. By signing exhibit and by signature exhibit 212/8 and 212/9 are of R.H. Khan approving the notes. Exhibit 13 is a supply order of to Devashish Bhattacharjee dated 14/11/2008 for supply of woolen blankets. 312 numbers at the rate so and so. In the supply order to Ma Trading dated 14/11 for supply of woolen blankets 313 at the rate of 800 rupees. Exhibit 21215 is a supply order to Bahrain dated 11/6/2008 for supply of woolen blankets at the rate of 800 each. Exhibit 21216 is the supply order to Ma Trading dated 11/6/2008 for supply of woolen blankets. And so are the signatures of accused R.H. Khan, which I identify. Now, Lordship will note, all basically Bahrain, Ma Trading, Devashish. These are sometime when the validity had expired.
Yes.
Exhibit 213 is a file relating to the purchase of office stationery articles for 2007 to 2009. I have dealt with the file and the notice BMI writings. The file relates to purchase of stationery. Exhibit so and so are the note in my handwriting, and exhibit 21312 to 21324 are the signatures of RH Khan for approving the notes. 21325 to 21329 are different supply orders to Ma Trading dated 27 to 2009. Loknath Trading dated 27 to 2009. Parel Enterprise 27 to 2009. Again, Ma Trading dated 27 to 2009. Mugarati Printing Press Lordship is not involved in this particular case. Exhibit 213/30 to exhibit 21334 are the signatures of accused RH Khan. The rate quoted in the supply order are as per approved by the council and not taking market rate by the department. By exhibit 21335, the department made the rates of articles of different items, and thereafter the same was sent to council for renewal of rate. The council by exhibit 213/37 approved the rates sent by the department. So it was approved. Exhibit 21338 and 21339 are the signatures of RH Khan. Exhibit 21340, 21341 are the two supply orders issued to JK Traders dated 12/11/2007, and this is ND Traders dated 12/11/2007. Exhibit 21342 and 21343 are the signatures of accused RH Khan. In this case, the deputy director instructed me to issue the supply orders to JK Traders and ND Traders as per approved rate of the council.
So the allegation regarding or the items have been procured at the double the rates.
That's
This is your witness speaking. Yes.
I have ensured receipt payment voucher of Social Welfare Department under the scheme of rehabilitation of BPL families for the year 2008-9. On seeing the bill and receipt, I say that the payments were made as per the bills.
So excess payment also goes.
As per the bills.
Hmm.
Because the allegation is, Lordship, the rates were inflated.
That's not what the witness says.
No, that-
Approved rates. So then you have to come out with a case that the approved rates were inflated.
Lordship,
Who says so?
that is of course.
Hmm.
By receipt exhibit 70/28, which is without date. The amount is shown to have been received by one Dhruvo. The bills 70/27 passed by accused RH Khan. The exhibit 70/29 and exhibit 70/30 are the signatures of RH Khan. Exhibit 70/31 is the bill which is without date. Lordship will note these bills, and in the evidence of some other witness, Lordship, it has come out that those were found in the computer, Lordship. Those bills made in different names. Is without date by Borel Enterprise for 19 so and so. By receipt, which is without date, exhibit 70/32, the amount is shown to have been received. The bill exhibit 70/31 passed by RH Khan. Exhibit 70/30 and 70/34 are signatures of RH Khan. Exhibit 70/35 is a bill which is without date sent by Debashish Bhattacharjee for rupees 10,40,000 by receipt, which is without date. Exhibit 70/36, the amount is shown to have been received. The bill, exhibit 70/35 passed by accused R.H. Khan, exhibit 70/37, exhibit 70/38 are the signatures of R.H. Khan. Exhibit 70/39 is the bill which is without date, sent by Ma Trading. The receipt, which is without date, exhibit 70/40. The amount shown to have been received by one Zubo. Exhibit 70/39 was passed by the accused R.H. Khan. Exhibit 70/41 and 70/42 are the signatures of accused R.H. Khan. 70/43 is the bill, again without date, by Ma Trading, is in 2 copies, without date and bill number. By receipt, which is without date, exhibit 77/44, the amount is shown to have been received. The bills, exhibit 70/43 was passed by accused R.H. Khan. Exhibit 70/45 and exhibit 70/46 are the signatures of accused R.H. Khan. I also find 3 copies of challans of Ma Trading without challan number and date. The challans is for rupees 10 lakh. The third copy of the challan is totally blank. Exhibit 70/47 is one challan, 70/48 is the other challan, and 70/49 is the blank challan. In all these 3 challans, including the blank challan, the storekeeper has put his signature on the printed words, received the above goods in good condition. Exhibit 70/50 is the bill which is without date, sent by Borel Enterprise for rupees 10 lakhs by receipt, which is without date, exhibit 70/51. The amount is shown to have been received. The bill, exhibit 70/50 was passed by R.H. Khan. Exhibit 70/52 and 70/53 are the signatures of R.H. Khan. 70/54 is a challan of Borel Enterprise. Exhibit 70/55 is the bill sent by HK Enterprise for rupees 63 lakhs without date. By receipt, exhibit 70/56, the amount is shown to have been received. The said receipt is without date. The bills, exhibit 70/55 was passed by accused R.H. Khan. Exhibit 70/57 and 70/58 are the signatures of R.H. Khan. Exhibit 70/55 is in duplicate. I'm also required to so and so. So what transpires from here, Lordship, is the bills are undated, receipts are undated, even challans have been, Lordship, I would submit, have been manufactured, because challans, blank challans, undated challans, he talks about all those things. And subsequently, when the computer of the office was seized, Lordship, these blank, Lordship, these bills and challans, those could be retrieved from that computer, Lordship.
Exhibit. Exhibit.
Good. itu tahe. Then I would take your Lordship to the evidence of PW. To 128. That your Lordship will find volume. Your lordship will find that at volume 3, page 635. Lordship has got 635.
Mukut Kemprai.
Mukut came, lordship. In the year 2009, I was working as secretary in charge, finance taxation, NC's Autonomous Council. In the last part of 2015, I was promoted to the post of principal secretary. On 12/8/2009, I received a letter from DSP NIA, New Delhi, seeking information as to whether Ma Trading, Loknath Trading, Jeet Enterprise, Orel Enterprise, and Devashish Bhattacharjee are registered in the financial year 2008-2009. Their local address, contact numbers, registration numbers. I received the letter personally, Exhibit 393. So another objection is a said letter. Exhibit 393, one is my signature receiving the letter. On 13/8/2009, I gave a reply to the above queries by sending a letter to the DSP NIA New Delhi informing that against the above mentioned firms, permits were issued on 31/1/2008 under serial number so and so in favor of Devashish Bhattacharjee, son of late Sujit Bhattacharjee, Lower Aflaw. And sales registration is being in the department and there is no contact number. And all permits were valid up to 31/3/2008. 31/3/2008 and no further and not further renewed. Exhibit 394 is a said letter, 394-1 is my signature. The aforesaid letter was prepared by me by collecting information from the concerned staff of our office. The registration of the contractor was done in PWD department and our office used to issue permits. Hence, the registration number is not available with us. So the letter I had just referred to that exhibit lordship. They had the validity of the permits had expired in the meantime.
What is the basis of issuing this letter? Read cross-examination and
Yes, Lordship.
argue. Third line, cross-examination of RH Khan. Third line, fourth line rather. The
The
register,
registers containing issuance permits and renewal of permits are not shown to me in court. My information answer to the DSP NIA was on the basis of the information which I collected from the concerned staff of our office.
who were the staffs? Why were the registers not taken by the NIA?
Lordship, they have
So this is a half-baked information. Not on personal knowledge, based on record, not even record, information provided by staff. So had he said that this is information based on what I collected from the registers, perhaps his evidence would have been more reliable. Now he says, simply some staff guy told me.
That is.
That is. Yes. Next.
Then whether the existence of these firms
Existence.
means the place, lordship. They could not be located, lordship. Here, I would
Will
refer to
you
the-
please just, while we are at this witness, Can we read the page 636, bottom 2 lines?
Yes, Lordship. It is
Then
true.
It is true, bottom 3 lines.
It is true that all the firms were genuine and registered
Hmm.
as per rules of the NC Hills Autonomous Council.
Hmm.
The registers containing issuance of permit and renewals of permits
That is
are
the same answer which was elicited above. Same answer. Not being shown to me in the court.
not being shown.
Okay. So now your postman who says, postmaster who says, I went to have a look at the firms. I sent a postman and he could not locate.
Lordship.
Read. PW.
41, Lordship.
Yes. Page.
Volume. No. These are 314, Lordship.
Yes. Haripada Barman.
Haripada Barman, Lordship. On 14/8/2009, I have written a letter to the superintendent of police, NIA camp, so and so, with reference to their letter dated 13/8/2009, whereby I was asked to furnish a written report regarding the existence of firms at Haflong town.
So just wait here.
Yes,
They were not registered at Haflong. Why they were to be found at Haflong? They were registered in Guwahati. They were registered with the GMDA, you yourself say. Is there any dispute?
not GMD.
Oh, the
GMC.
Municipal corporation.
Municipal Corporation, GMC, at that time, yes.
I'll just explain, Lordship.
Where the registration, Mr. Chaudhary, registration of a firm is done by the registrar of firms. Was there any office of registrar of firms in Haflong? As per you, as per your IO, what was the address of these firms? Or you read this witness?
Yes.
You will yourself find out.
On 14/8/2009, I have written a letter to the superintendent of police, NIA, Camp Circuit House, Haflong, NC Hills, with reference to their letter dated 13/8/2009, whereby I was asked to furnish a written report regarding the existence of firms at Haflong town.
Lower Haflong, upper Haflong. Yes.
Haflong town area, namely so and so. On inquiry,
Was not completed.
Yes. Carry on, carry on.
On inquiry, it was found that the aforesaid 5 firms were not traceable under the jurisdiction of Haflong MDG. Accordingly, by my letter dated 14/8/2009, I informed the NIA that the firms were not traceable. Exhibit 20 is the letter dated 13/8/2009, received by me from the SI of police, NIA Camp Haflong. Exhibit 120/1 is my signature. As a token of receipt of the said letter, Exhibit 121 is my reply dated 14/8/2009, and 121/1 is my signature. We received letter from booking counter And after receiving the letters, the same are given to the postman preparing the list for delivery to the address. In Haflong, there are delivery beats and letters are allotted to the respective postman of the beats. After delivery of the letters, the postman gives his report of the delivery, and those letters which cannot be delivered because of address not found, they are returned. They are returned as the address is not found. The same letters are again allotted to another postman of another beat for delivery. If the letters are again returned as with the remark address is not found, in this way all the 4 beats are covered, and thereafter ultimately when the letters could not be delivered, the same are returned back to the postmaster, and thereafter the postmaster sent back those letters to the senders with the entry in the list through the booking counter. Exhibit 1221 to Exhibit 1223 are different registered letters sent by NIA, MHA, Government of India to these are the letters, Lordship. In fact, Lordship, it appears that 30 letters were sent, not even one was delivered.
319. Top 4 lines. What was the effort made? It was a great deal of expediency.
On 13/8/2009, I was called by the officer of NIA. And accordingly, in the evening, I went to the NIA camp at Circuit House, Haflong. Then this letter white exhibit 120 was handed over to me by the NIA. On the next day, I have submitted the report.
So 30 letters within a matter of 1 day.
Lordship.
Okay. Then come to 324. Whether the task was given to the correct man.
Middle.
324.
Lordship is referring to the middle. It is correct.
Yes.
It is correct that Lower Haflong Branch Post Office falls under the Haflong Police Training Center Sub Post Office, which
Does not fall under my jurisdiction.
Lordship.
So was the location which was being searched correct? They only need to create a doubt. The task of proving it beyond all manner of doubt is on you.
Lordship, I will try to take out some documents where
Yes, yes.
the address itself is linked. They are bills.
Exhibit 394.
Exhibit 394, sir.
But then above all, let us know within a matter of few hours whether these reports should have been procured. Postman sent to 30 different addresses, brings back a report. Were they prepared in the sitting in the office or actually someone went there? This much of
Personally,
expediency.
Lordship, my experience is Haflong is not that big, Lordship.
Is it a hilly area or not?
It's a hilly area, Lordship, but even
that
I stay
big.
on a hill. Even I stay on a hill, but that does not make Lordship. It's not. So,
Ms. Chaudhary, Shillong is at a distance of 100 kilometers from this place. 120.
100.
100. Talking in Rajasthan terms, that takes us 60 minutes. And here it takes 3 hours. So that big, we have to think in those terms.
No, still, Lordship.
Okay, very well.
I would not say.
What is the actual address of the firms in Haflong?
I would try to show you.
Sure. And if these firms were non-existent, who supplied the material?
that is what lordship, the materials were not supplied.
That, yes, you are entitled to argue. That you are entitled to argue, yes. Then why did your
Because-
CBI counterparts not charge sheet them? Mr. Kumar, we have put a question that what would be the fate of them not applying the offences of penal code 409, 420, 467, 468 and still putting that language in the charge. Whether without the offences being applied, the conviction could have been on those counts.
With all respect, it cannot be.
So we need your active assistance on that,
Absolutely.
not a bald argument,
Yeah.
proper law-based argument.
I am good too, but on the legal aspect, I'll try to say.
Yes, yes, because we have called for those charge sheets also.
Yeah.
The charge sheet we are having. That charge sheet, they have virtually given up the firm owners. They said that excess amount paid recover, that's all. No incriminating material. That's what the conclusion of CBI is.
I've also come to know, my lord, that already one firm and 2% has already been acquitted of that.
So they were discharged by the CBI. They were not charge sheeted actually. That's what the charge sheet reads.
PHE.
Chali, all right, carry on.
You are saying.
He is taking advantage of my ignorance of the language.
No. He was simply saying, in one hand, they are catching the by the collar, in the other hand, they are leaving the collar.
If one lordship, 150, PW 174.
174, there is no
Oh,
PW.
I'm sorry, lordship. Again, amend given. Amend. Sorry, sir, it's 74.
4,
470.
Oh,
470. Read. Yes.
May I read, lordship?
Mm.
In 2009, I was working as sub-inspector of police in Special Task Force, Ulubari. I was attached to NIA in the same capacity. In 2009, the DSP NIA KS Thakur directed me to verify the address of Barel Enterprise Factory at Ulubari and Loknath Trading Factory at Paltan Bazar. Accordingly, I made local inquiry by visiting the area and asking the people of the area of the existence of two firms. I also visited Guwahati Municipality Office. Lordship was on this sometime back at East Sarania and at Pan Bazar, and contacted the official who checked the registers in my presence. But by my
Could he have been the witness, gentlemen? Could he have been the witness to say so? Could have called the officer from the GMC. He would have come and said,
my if I may say so, lordship, even the GMC cannot say that.
Okay.
Because they only issue a trade license for and this is not a registration, something like.
Precisely. He was required to go to the registration, registrar of firms for the checking the registration.
Only I would not go by this lordship because this is a misplaced.
Otherwise, also he is not the witness. The person concerned should have been the officer from the municipality.
If at all.
You wanted to prove the trade license
If at all.
or the absence thereof. All right, we'll carry on at 2.
Lordship.
Yes. 1990.
Yes, we have I-17.
Hmm?
No, volume 2, we have I-17.
Yes. Hmm. 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 Oh, gentlemen, come to 521. That's again one more certificate of appreciation for your NIA. Read. Hmm? No. Your this at top 5 at top page 521. Today on being shown. Yes. Hmm. And hmm. Hmm. Then uh, in chief he says we have retrieved this information and submitted our written reports along with the DVD to the NIA. What were the contents of the DVD, sir? That is played in the court. Okay. DVD. Hmm. 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 Okay. Were these iodized sent? And above all, Mr. Chaudhary, who prepared the report? Who undertook the exercise? Hmm? Who? Where is Satish Kumar, sir? So Satish Kumar extracted all the files in a DVD and you presented the DVD in the court. So that is secondary evidence, 65B. Hmm? So playing the DVD in the court, what is the purpose of that? Very clear answer. I have not personally prepared the DVDs. So he is not the witness who undertook the examination, scientific examination. He is not the person who extracted the files in an external drive or external device. And Satish Kumar is not there before us, and the 65B is also not before us. And above all, the report 304, let us see, 305. Page, exhibit paper book, volume 6. (306). One 1331. You have it? Read the title page. Preliminary cyber forensics. So no conclusions. And what does the report as such indicate? Any conclusions in the report? No. So Whatever has been concluded is in the DVD, we presume. Witness doesn't say it in his oral evidence as to what was the conclusion of the exercise. And DVD prepared by someone else. How does it get acceptance without 65B? And then one more question. Who sent that hard drive to this CDAC? Where is the forwarding letter? This is 132. One, 3, 2, 4. Who is the witness who sent it? Three, 0, 4. See at page 1328. No one has proved the signatures on this forwarding letter. So the lead we gave Mr. Burgoyne, link evidence. You see this 1328 specimen seals, impressions of exhibits, parcels with sealing wax and so and so. This is a procedure meant to ensure sanctity of the transited articles, sealed condition. So the DVD or the hard drive, if it is not sealed, anyone can put anything in that. Where did the DVD remain after it was sealed? Tell us, please. Oh no, that hard drive. Who was the custodian of the hard drive after it was sealed? Your CIO must be the witness who can throw some light on that. Custodian of articles. She is during course of investigation. All right, you just find out later, but for the present, you tell us. What indication do you get from this report? The report simply says, we have enclosed the preliminary analysis report, attached 2 DVDs. Kindly note that we have retrieved data. So data retrieval, once it comes out, then it falls within the category of secondary evidence. And if it is secondary evidence, then 65B. How do you escape from that? So the trial court playing the DVD in the court, it is hardly of any interest to us. Was the DVD opened in the, during the evidence of this witness? Hmm? If it was, so then the statement doesn't indicate. Read page 520. Even the DVD was not sealed. When was it played? Yes, page, para 153. Yes, please. Yes, please. Come to para 12 at the bottom. 153.12. 13, yes. All right. Is there any proceeding recorded to this effect, please? Your special PP might be knowing. Because if this is written, then once you present the document in the court in a sealed condition, the CD, it's a custodial aegis. So any effort to open it can't be without permission of the court. Yes. Yes. It is recorded in the trial court's proceedings. To check it out. There has to be, otherwise that would be order sheet, obviously, we understand. Yes. And now you come to the bottom line. Learned PP further submitted. Now, this is an absolutely unacceptable conclusion. You want to rely upon the original, right? So, all right, play it from the original. Display these records from the original. You are still relying upon the DVD. Who prepared the DVD? Satish Kumar. Satish Kumar is not in the court. Satish Kumar could have come and said, I did it. Now, the defense wants to cross-examine. No, your procedure was not correct. The defense could have taken technical aid, but the witness who extracted the data and prepared the DVD was not examined. So how is it to be accepted without 65B? Let us know. Yes, read Anwar PV. The situation had been different. Second para. If the CDs used for announcement has those CDs used for objectionable songs or announcement been duly got seized through the police or election commission, and had the same been used as primary evidence, the High Court could have played the same in the court to see whether the allegations were true. The speeches, songs and announcements were recorded using other instruments, and by feeding them into a computer, CDs were made therefrom, which are produced in the court without due certification. Same situation. You had the hard drives with you, the CPU with you. You should have asked your expert, all right, play it in the court. That was not done, so that was not done. Yes. Okay. So this part of your evidence, DVDs, the defense would argue differently that no 65B, no DVD. Then next. And before that, of course, we'll ask you to provide us the evidence regarding safekeeping of these CPU and the hard drives. Who has stated so? When was it seized? Who forwarded it? What was the document? What was the condition? Because if the instruments, if the hardware is open, there's every possibility of tainting it. Which is the seizure memo? What is the seizure memo exhibit? 64. See whether it was sealed while it was being seized. Let's see. Even your, Mr. Chaudhary, see your report, whether it says that they were received in sealed condition. That is the answer. That is the test, as a matter of fact. Let's see. Received forwarding note. And by the way, Mr. Prosecutor, why were you required to open both the CDs, DVDs? Why was there a need to open both the DVDs? The data was in one DVD, the other was a copy. So why you broke the seals of both? Read page 1330. Exhibit. We have enclosed the preliminary analysis report and also attached 2 DVDs, one original and one copy. And then when they were received, what was the condition? Where is the receipt note? Forwarding note you have announced. Where is the receipt note? Receipt at CDAC and receipt back by the NIA. Where is that link evidence? $65 you were saying? 65 is the forwarding letter. Mr. Chaudhary, you are saying that the forwarding letter is 65. He was saying that 65 he was referring to. What is 65? Then Caesar memo. Receipt memo. These are files by, yes. So who received it in NIA and in what condition? He doesn't say that when we sent the DVDs, they were in a sealed condition. Even the letter doesn't say. So what is the guarantee that you did not substitute it with a fresh set of DVDs? Which is the Caesar memo? Caesar memo of this order, 64. 64, let us see. 282. 282, yes. Sealed in envelope by seal impression, which is embossed below. This is Santosh Kumar. What is the PW witness number, Santosh Kumar? 148. 148. Let's see, 148. Then our last paper. 697. Yes. What he did of the hard drives? After seizing the hard drives, to whom did he present the same? There's a question. Yes, let us see that. Yes. 716, third paragraph. That, of course, he says that he had handed out. They must have been broken by the CDAC. But then again, CDAC's report doesn't say that they were received in a sealed condition. And even what does this your CIO say about this forwarding business? Let's see right now. CIO is last volume. Volume 4, you know. Where does he say that he received the DVDs, the hard drives from Santosh Kumar and then forwarded it to the CDAC? Let us see. Come to page 762. It doesn't utter a word. Rather, Mr. Chaudhary, last 2 lines where? Page? He doesn't even say that the letter was sent in his signatures, under his signatures. It's a fact that the signatures are of this man. Now, whose negligence is it? Okay. Carry on now. From where do you propose to read? So this is your part of DVD. And the Santosh Kumar was PW 148. Yes. This was the electronic evidence on the basis whereof you tried to link him. No oral evidence? All right. Okay. Next. Yes. 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 AW1. Hmm. Yes. Hmm. Come to the relevant part. Jayanta Ghosh came on 21st March, 23rd March, 19th March. So he was a regular visitor. Yes, then. PW 116. Yes. Hmm. Hmm. Have they identified him other than name? Hmm. 1-1. Hmm. He is the person who was forced to sign the checks. Yes. Kalyan Brother. Hmm. 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 Does he say so? Does he say so? Does he say about presence of anyone else other than Mohit Ojai? Read, please. Hmm. Yes, all right. K. Namsudra came to the hotel. Hmm. Right. Okay. 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 Yes. So they were present. Okay. Hmm. Under pressure. Okay. So what is the consequence of this? Assuming for a moment that this payment was got released. Why didn't you put a question to this witness that look here, the permission of these firms had expired, and despite that the orders were placed. He was the concerned man. Why did you put him the question? Okay. So all right, what you want to gain is that Mohit Ojai was responsible for pressurizing this man to issue the checks, Ma trading, even though the supplies had not been completed. Okay. Hmm. 104 Jayendra Ojai. Okay. Hmm. 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 All right, he has said that these were the checkbooks, checks which were used, check leaves. In cross-examination, please see. None of the checks for the amount was transferred before 2nd April. So even probably the trial court has given a finding that these amounts could not be linked to the 1 crore which was being carried. Is it right? It is linked with the opening of a bank account. All right. Well, okay. Very well. Okay. Very good. So these two witnesses, as per you, prove the fact that the executive engineer was forced to make the payment. Okay. Yes. Right, 26. Galvanized, yes. Hmm. So KB Mukherjee says about an event of March. He doesn't say that even before that there was any pressure on him. This is of February. Yes. Hmm. Hmm. Not made. Hmm. Yes. Srivel Masa. Hmm. These are probably relevant for NIA too. Dilip Fanglo, Munna Fanglo sir. What is he said about these accused? In cross by Mohit Ojai, he has said that these same evidence I have given in CBI special case number 12/10. Mm. Mm. Sushil Chandra Das. Mhm. Mm. Does K.C. Namasudra say so? That he, under the pressure of Mohit Ujai, he pressurized his subordinate. He was dropped. He was dropped. All right. Okay. Hmm. Yes. Goods meant for Aflong were sent to my bong. That's why your witness admitted. That is why excess. You recollect, there is one witness who said so. That's why. Hmm. Made in advance, goods were received later. Or received later. Assuming that, sir, assuming that we prove what was the charge required to be put to the accused? What were they to be tried for? Hmm? Fabrication of documents. This is fabrication. Antedating the receipts. It's fabrication. Where is it? 420, 467, 468, 471. And of course, 409. Why they were not applied? You couldn't have anticipated or left it to the mercy of CBI. That is all right, they will take care of the things. CBI could have been given only for 13(1)(d). But the other offenses, they were required to be applied here. So this is a case wherein findings of offenses defined under the IPC have been given without there being a charge. How that is possible? Yes, all right. Yes. What does he say, sir? His second page, top two lines are somewhat interesting. First three lines. Hmm. 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 So read the top three lines. That is why we said. Top three lines, page 2, 340. Hmm. Hmm. Open market and registered dealer approved rate. Three things he says. So now come out with your case that the pipes were procured at more than the approved rate, that they were not procured from the open market, and that the suppliers were not registered contractors. Of what? License. Where's the document, gentlemen? And then this witness says only registered contractor is required. Hmm. Hmm. What do you want to get out from this statement anyhow? You put your arguments in your own way. Hmm. Okay. Hmm. Okay. Hmm. P46. Okay. Hmm. Hmm. It's okay. And why do you want to read these details? Hmm? They're all statistics. Come to the crux of his evidence. Hmm. Yes. Invalidated by they were beyond the expiry date. Where is that document? Hmm. Yes, read. Hmm. What is the page you're stating? 845 exhibit. Yes. Uh, uh, hmm. 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 26 to 2009. Yes. That's an oral statement you read, sir. Is there any document to support? And the order is being placed by the additional chief engineer. Why is he not an accused? Karuna Saikia was the additional chief engineer. Karuna Saikia was there. All right. He is Karuna Saikia. Okay. All right. Okay. Hmm. Yeah, there are n number of orders. Yes. Hmm. KB Mukherjee. Okay. 8.6. So, Mr. Chaudhary, when you said that the orders were placed to the firms who were 846. Volume 4, 846 can't be the page. That what you are reading. Well, 313 statement. Exhibits. KB Mukherjee has appeared as a witness. Kalyan Brat. Who is the PW? Let's see his statement. Yes, you read it now. Let's see that. Let's see once again. Yes. So, did you put any statement to him as to why you placed the orders to firms who are not having a valid agreement or license to deal with the council? Additional charge. Karuna Saikia was the AEN's assistant engineer. What was Karuna Saikia? On what date? No. What was the date? When did KB Mukherjee join? 2009. What is the date? After Karuna Saikia must have been arrested in this case. After arrest of Karuna Saikia or what? Do we have any date of his joining? Obviously, it is in March, before March. When exactly did he join? Yes. Come, Ms. Chaudhary, come to page 539. Bottom 5 lines. In the month of March 2009, I remember to have issued supply order J pipes to Mart Trading. So he was responsible for issuing the work orders. Why didn't you? Yes, this is the very period. It is correct that I was the executive chief engineer, PHE, from 26 to 2009. So those letters you are referring, let's see those exhibits again. Yes, those are probably signed by Karuna Saikya. Because Kalyan Bhatt's signatures are different. No. Read 541. But he, in any event, he continued to place the orders. Right now, you're referring to the orders. No? What was that exhibit? Page 845. Yes, they are not in the signatures of Kalyan Bhatt. Definitely not. Hmm. Okay, continue. Very well. Hmm. Hmm. Ah. Yes. Yeah. So before that, Karuna Saikya must have been doing. Yes. Hmm. Hmm. What do you want to, Ms. Chaudhary, what do you want to show from this? Yes. That there was a delayed supply. No, could not be verified because were handed over to the executive engineer. You're reading at page 589. Yes, read. Hmm. 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 Executive engineer. Yes. So where is the question of verification? The suppliers were in jail by that time. Hmm. 176 paper book. What is the page? Yes, Manoj Talukdar we have read. What is the page you are referring to of exhibit? Page 846. Hmm. Of KB Mukherjee in the statement of yes, that KB Mukherjee himself says 26-2 I place the order. KB Mukherjee himself says. So that's what the question was, Mr. Chaudhary, that why didn't you put a question to KB Mukherjee that how could you place the orders without the firms being having the permission permit expired. So why he did place those orders? It's not his case that for placing these orders also he was pressurized. For making payments, yes, but not for placing orders. Then yes. Mhm. Yes. So a presumption is drawn against him. Hmm. He is PW? Yes. PW? 30. Volume 1. Ah, we have it. Yes, page. Hmm. Yes. Hmm. Hmm. 159. Hmm. 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 Yes. Hmm. Yes. Signatures of RS Khan are there on all these vouchers, bills, whatever. Yes. What is to be gathered? Hmm. 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 Yes. At Bangalore. Who is the witness who says? Hmm. Harboring. Is there a charge? Harboring. You made a statement that they were residing together. No, not question of charge. You want the court to infer the ingredients of conspiracy by that. So who is the witness who says that they were living together? Bangalore is a big city. So simply because being found in Bangalore can't give an inference that they were living together. One was found in a gym, one was found in a flat. So you have already summed up. Yes. Yes. Not Sandeep. He was the other one was who confessed. Yes. Ahmad something. What was that? Samir Ahmad. Yes. So Ashrind Wariso, what do you want to say? All right. Tomorrow. Then what do we do for the remainder of the day? Still 45 minutes to go. Ceiling. Will hear you. You found one. We have got dozens. Don't worry. Anyone is intending to reply to what he has said? You come forward, sir. He has already argued about Aris Khan. Yes. Why not utilize the time? I was told. We were told that. Hope that he recovers quickly. Wishing him well. Yes. What is the problem actually? What has happened? Oh. So he will not be able to address us for this entire week. So, from judgment. Just hold on. And we would request you to do one exercise, you and Mr. Borgoin both, the contradictory findings in the judgment. We need a note on that. There are a few contradictory findings we have found. 419. This is for Mohit Ojai. Ojendra Ojai, yes. Yes. That we have marked. It is however true that there is no direct evidence. That we have marked, yes. Yes. Didn't go to Ojendra Ojai, yes. No, that is not the finding actually. You are reading at para 15th line. All right, read please. Yes. Yes. And what is the basis of this finding? That before his arrest also, accused Ojendra Ojai carries a sum of rupees 1 crore and 2 crore and 1 crore to Kolkata and handed it over to Balsam Kimi. This is based on George Lamthang. Okay. Yes. All right, Mr. Kumar, come. Yes. Okay. Very well. Queries, not really, not many. Yes. There was one query we made in the morning. we would like to respond to that. Yes. Whether those findings could be recorded in form of an incriminating circumstance. Mm. 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 Yes. 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 Mm. That's right. That's right. Yes. That was precisely what the question was. What, assuming that the CBI had been given the part of investigation, what prevented the prosecution from praying to the court or filing a charge sheet for at least the IPC offenses? They could have sought sanction and charge sheeted the accused at least for the IPC offenses. And even then, sanction was not even required. Sanction is for an act done in discharge of official duty. This you could have come out with the case that this is not even the color of discharge of duty. It's pure fabrication. There are few judgments which say, Ms. Chaudhary, there are few Supreme Court judgments that if a public servant indulges in fabrication, that fabrication is not a part of official duty. So no sanction needed. So why we want to know again and again, why didn't you propose a charge of fraud, forgery, and criminal breach of trust or misappropriation? Why didn't you frame a charge against them? The clear-cut case. What you are trying to prove is a clear-cut case of these offenses. You have incorporated the ingredients of these offenses in the language of the charge, but you don't charge them for these offenses. Then Mm. 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 Yes. Yes. Karuna Saike and Arij Khan. Mm. Mohit Hossain. Yes. To the organization, yes. Mm. 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 No, that is not their case. They have come out with a case that you connect all the facts and you get a virtual kind of a cocoon of conspiracy. That's what they are trying to say. Yes. Obviously. Mm. 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 Hmm. 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 But they have come out with a case that you gave out all the payments to the firms which were not having their licenses extended. The payments were made in advance, goods were not received. That all kind of allegation is there. Okay. Very well. Different kind of. Say those mar trading and everything, they are concerned with PWD. PHE. Devashish Bhattacharjee. Only on Loknath trading. Okay. Approve the rate. But so far as Loknath is concerned, there is no allegation that his firm was not having that permission to trade. That is not the allegation. Okay. And or what has happened to the CBI case against Arij Khan? That's still going on. Can you give us what are the charges in that? Please give us that. Yes. Okay. So you have prepared the brief. Let's have it. Who else has the written arguments ready in hand? Please. Yes, please. Already given this. Mr. Burgoyne, where are your written submissions? All right. Okay. You will be doing it for Niranjan Hojai. Let him conclude. Yes. All right. Okay. Yes. Okay. Okay. Very well. Yes. You will give tomorrow? All right. Okay. What deals with? Chapter 27. Yes. Mm. 464, yes. What will be the infirmity which vitiates the proceedings? Failure of justice. So you have to satisfy the court that there has been a failure of justice. How would you do that? All right. Bring out the judgments also on this. Okay. ये भेज देना.